Good afternoon. This is the House Judiciary Bill hearings for January 29th, 2026. We're going to start with Delegate Kaufman's bill, House Bill 137. And we're going to call up Eileen King. If she's not here now, I'm sure she'll be here shortly. I saw her earlier today. So Delegate Kaufman, whenever you're ready.
Thank you, Madam Chair. It's good to be back. I'm clearly having separation issues from you guys, although maybe that's not the best choice of words to use today, but since we're talking about child custody. So what I wanted to talk about today is a bill that I brought three years running, and that is a bill that establishes clear statewide qualifications and training requirements for child custody evaluators by Maryland courts. In contested custody and visitation cases, judges often rely heavily on custody evaluators to assess family dynamics, child safety, and allegations of abuse. Despite the significant weight courts place on these evaluations, Maryland law does not set uniform standards for who may serve as a custody evaluator or what training they must complete. Research shows that this gap has real consequences. National and international reporting have documented cases in which underqualified or undertrained evaluators failed to recognize domestic violence, misplaced, discredited theories, or minimized coercive control, leading to unsafe custody outcomes. Now, you have before you my testimony, and I'll get back to it, but I want to spend the majority of what's left of my time responding to the criticisms of this bill. You hear from the judiciary that it's best for it to be in the rule because there's greater flexibility. Well, I don't respectfully disagree with that because we change things all the time. For example, since cannabis was legalized, we've tweaked it every year, so we constantly are tweaking things. Secondly, this is not unprecedented as there are judicial training requirements in the rule, but also in statute based on what we passed in 2022. And I don't enjoy taking on the legal establishment, but I keep doing it because the status quo works for the legal establishment, but not for Maryland families. And I also want to address the concerns people had about SINA. And this is from a former vice chair of the committee, Judge Dumais. And she said, the bill's amendment request regarding SINA does not require a rule change as the rule does not apply in SINA cases. The revised rule protects the jobs of the 2 county employees who have completed the mandatory training and have over 20 years of experience conducting evaluations, but do not have one of the required licenses. So, and it's a separate statute also. And so what I'm really hoping, there are a bunch of amendments that people want on this bill, and I'm going to work with my Senate sponsor, Mary Beth Carrozza, but this is my 3rd year bringing it, and I will bring it until it passes, but it would be really awesome if it passed this year. What I want to talk to you about is the fact that locally speaking, in the state of Maryland framework, the Maryland Department of Health Child Fatality Review from 2022 reports that among the 184 child deaths that occurred in 2021, local CFR teams reported 19 deaths, 10 resulting from confirmed abuse or neglect. I also don't see the harm in having this legislation in both, having this in both the rule and the statute, because that's what we did for judicial training. And then on a local note, in Montgomery County, where I represent, it said Cynthia Moore, a mother of 7, was convicted of 6 counts of child neglect, with one of her 7 children, minor children, a teenager weighing just 79 pounds. The evidence portrays the need to ensure child custody evaluators have training and expertise that Maryland families deserve to ensure the safety of the children in our midst. And a lot of them didn't come back this year because it's dramatic, but you've heard heard year after year about the consequences of when child custody evaluators don't get it wrong from mothers and children alike. And so I just think that this is common sense legislation that needs to pass. And I thank you for your time and will happily take any questions.
Thank you, Delegate Kaufman. And Ms. King, Ms. Eileen King, if you want to come on up, please, so we can hear your testimony.
Good afternoon, Chairman Bartlett, Vice Chair Davis, and members of the House Judiciary Committee. I'm Eileen King, founder, Executive Director of Child Justice. We provide free legal services for protective order and child custody cases with compelling evidence of child abuse. My thanks to Delegate Kaufman, Arakan, Foley, and Taylor for sponsoring HB 3137. So it's 30 years I've been doing this work. When you walk into my office, you'll see pictures of 4 children who have died because of system failure in Maryland. Colin Horridge, Anthony Austin, Athena Castillo, and Prince McLeod. The most crucial lesson I have learned in the hundreds of cases that we have handled is, when we know better, we do better. Child justice was encouraged by the passage of the Judicial Training Bill in 2022. Thank you. But knowing better and doing better also applies to child custody evaluators, upon whom judges often rely to make their decisions, which can be life and death decisions for children. Evaluators sometimes dismiss pictures of horrific child abuse or domestic violence. They sometimes ignore the child's forthright disclosure of sexual abuse or other abuse. And I will never forget the day when Hera McLeod called me to say, in August of 2012, I know he's going to kill my son. And by October, her son was dead at the hands of his father. We were encouraged to see the judicial rule, which includes the child custody work group's recommendations for evaluator qualifications, but we think this should become law. In 2006, I helped get passed HB 700. This was court-appointed attorneys for children. Afterwards, a rule was added defining the roles of best interest in child advocate attorneys. There is no rivalry between rule and law. They support and affirm each other. This is collaboration and cooperation, not competition. It also supports the legislative intention to protect children in Maryland. Making HB 137 lets your constituents know that you have heard them, that you understand, that evaluators as well as judges should know better in order to do better. Thank you, and please support this bill.
Thank you. Members, do you have any questions for this former Judiciary Committee member who left us? Surely you must.
Delegate Simpson?
Chair Kaufman.
One day, maybe.
There we go.
Well, it's very good to see you, Delegate.
It's always good to see you.
Yes, and you're welcome back anytime. Looks like we don't have any questions.
Thank you very much.
Thank you.
Thank you.
And I believe that concludes our testimony for House Bill 137. We're going to move on to House Bill 83 with Delegate Bartlett. I'm going to transfer over to the Vice Chair so that I can get myself ready. Just one moment.
Court's indulgence, right?
Oh, that's right. Oh, yeah.
I asked for a favor report.
All right, our next bill is HB 83 with Delegate Bartlett. Please call your panel, your sponsor panel to the table, please.
Sure. We're going to add, nope, we have everyone for this panel because we're only going to do 5 at a time.
Thank you.
Thank you very much.
I think she'll have you waiting.
Yeah. Good afternoon, Chair Davis. Good afternoon, wonderful distinguished members of the House Judiciary Committee. I am honored to bring back a bill that you all heard last year. This is House Bill 83, the Family and Law Enforcement Protection Act. House Bill 83 prevents domestic abusers from having access to firearms after protective orders have been issued against them. This bill provides several safeguards to protect survivors of domestic violence. First, House Bill 83 requires that every individual filing a petition for relief from abuse, if known, to include information about whether the respondent holds a valid gun license or permit and whether they own or possess a firearm. If the respondent possesses a license or a firearm, additional information such as the location of the firearm, the make and model, and whether the respondent keeps the firearm in their car must be included in the petition. Second, House Bill 83 requires certain measures at every stage of the protective order process. When an interim protective order is granted, the petitioner must be provided safety and support resources, including information from the Maryland Network Against Domestic Violence. For both temporary and final protective orders, the respondent must surrender any firearm and license or permit to law enforcement and cannot possess or purchase a firearm for the duration of the protective order. And third, House Bill 83 adds certain procedures for the respondents to surrender their firearms, including a 24-hour period to surrender or the opportunity to submit an affidavit if the respondent is not in possession of a firearm. Additionally, the bill implements protocols for law enforcement, including the retrieval of the respondent's firearm, written proof of surrender, and procedures for the respondent's noncompliance. Under current law, there are just too many gaps that fail to ensure individuals subject to protective orders and do not continue to pose a threat to their victims. As we know, in 2024, the U.S. Supreme Court affirmed in United States versus Rahimi that, and I quote, an individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed consistent with the Second Amendment. This legal framework allows for provisions just like the ones laid out in this bill. Although not every domestic violence case involves the use of a firearm, recent cases illustrate the consequences of easy firearm access. In May 2024, a father in Elkridge killed his wife, daughter-in-law, and daughter and hurt his adult son before committing suicide. In 2024, my neighbor's boyfriend killed her daughter, her husband, and shot their son before committing suicide. In 2024 of June, a 12-year-old girl from Baltimore was shot and killed by her mother's former partner, who had previously threatened the family. These stories are not isolated incidents, unfortunately, and instead reflect that each year dozens of Marylanders lose their lives to domestic violence. At its core, House Bill 83 reflects the reality that domestic violence often does not end when a victim seeks a protective order, and rather it often escalates. as you will hear from the panelists today. This bill provides a proactive and life-saving approach to lessen the devastating effects of domestic violence by strengthening firearm relinquishment law in Maryland. House Bill 83 will significantly reduce the risk that a perpetrator of domestic violence can use a firearm to kill themselves, their victims, or law enforcement. Ultimately, Maryland must prioritize the safety of domestic violence victims by ensuring that protective orders come with meaningful enforcement protections and not just a mere piece of paper. For these reasons stated, I urge a favorable report for House Bill 83, and thank you, committee, for your consideration.
Thank you. Your first witness?
Do we get 2 minutes or a minute?
2.
Okay. I have 2 different plans. All right. Good afternoon. I am Karen Herron. I'm the Executive Director of Marylanders to Prevent Gun Violence, here in support of the Family and Law Enforcement Protection Act. At the federal level, 18 U.S.C. 922G8 addresses firearm possession at the final protective order stage, but it does not apply at the temporary stage and provides no mechanism for prompt, verifiable relinquishment. This is a gap that states are expected to fill, and many states have long since done so by requiring firearm prohibitions at the temporary order stage, when courts have already determined that there is a credible risk of harm. This is a time and court-tested approach that this bill would adopt for Maryland. Current Maryland law recognizes that firearm prohibitions are appropriate in domestic violence protective order cases. However, courts are not required to impose those prohibitions at the temporary stage. This bill closes those gaps by making firearm relinquishment mandatory at that stage and by establishing clear and enforceable process to ensure compliance. So the prohibition is not merely just paper-based, but real, verifiable, and actionable if law enforcement must intervene. The bill practically does about 5 things. It builds out the petition and court record to document firearm access. It requires firearm prohibitions at that temporary stage. It allows sworn attestations under penalty of perjury when a respondent claims they do not possess firearms. And it creates a record, the record needed to support probable cause for a search warrant if the respondent fails to comply. And it makes compliance logistics clear to respondent. Finally, this is the product of more than 2 years of collaboration with stakeholders across the system, victims advocates, law enforcement, the judiciary, and others, because we know that a workable process is what saves lives. We respectfully urge a favorable report. Thank you.
Thank you. I mean, yeah.
I think you're next. Yeah.
Good afternoon, Madam Vice Chair, members of the committee. My name is Laurie Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence, which is the coalition that represents the domestic violence service providers that exist across our state. Thank you for having me, and thank you, Chair Bartlett, as well as Senator Hedelman, who has this bill on the other side. As my colleague just said, this is a concerted effort by a lot of stakeholders, and I want to commend both sponsors for the work that they did over the interim with us to really try to craft a tighter, stronger bill for this year. I just want to talk to you a little bit about the reality for domestic violence survivors and victims. You know, from 22 to 23, the National Domestic Violence Hotline saw nearly 30% increase in calls that referenced firearms. Over the 10 years from 2014 to 2023, there was a 22% increase in intimate partner homicides of women, driven by guns, which increased by 36%, whereas by other means only increased by 3%. So this is a real problem. People are being killed by guns by their abusers. I want to commend you. In my testimony I gave you, and I don't know whether it prints out nice and colorful for you, but for me it does, the fatality review that the network does every year for intimate partner fatalities in Maryland in particular. You have a 5-year, and then we start over again in 2024, so you have the 1 year. And In that 5 years, 75% of the fatalities, and I'm not talking about just the victim, I'm including bystanders, I'm including children who are killed, some of the things that Chair Bartlett mentioned, as well as, various other people. It is a societal problem. It's not just one person. And so we ask for a favorable report because this is a reasonable way to go after people who have been adjudicated to be an abuser. Thank you very much.
Thank you, Ms. Ruth. The next witness, please.
Good afternoon, Vice Chair, Madam Chair. My name is Debbie Feinstein, and also good afternoon to members of the committee, of course. My name is Debbie Feinstein. I'm the Chief of the Special Victims Division in the Montgomery County State's Attorney's Office. I also have the privilege of co-chairing, along with Joyce King, the Deputy State's Attorney for Frederick County, the Maryland State's Attorneys Association Special Victims Legislative Subcommittee. I also am here today representing the Maryland State's Attorneys Association as a whole. We are here to support House Bill 83. In addition to the roles that I just cited, I also have the privilege and honor of chairing the Montgomery County Domestic Violence Fatality Review Team. Fatality review teams like this exist in most of our jurisdictions throughout the state. And what we do each month is that we review cases of fatalities and near fatalities involving domestic violence. We reconstituted about 10 years ago, and during that time, we've reviewed 16 cases. Almost 50% of the cases that we reviewed used a firearm as the fatal or near fatal weapon. More than half of the cases that we reviewed involved termination or separation of the parties, the victim and the perpetrator, and a belief that the victim had a new intimate partner. These are the exact circumstances that House Bill 83 seeks to address. At the moment in time that there's termination or separation and someone seeks a temporary protective order, this bill closes a gap. It requires that the court issue a firearm surrender order at that time rather than waiting until the final protective order. This is a process that's been approved constitutionally, that's been approved in Maryland, and we should see it through to this stage, the temporary protective order stage. I'll also use the remainder of my time to speak to the search warrant process. There have been concerns that the search warrant is not a probable cause-based effort in House Bill 83. I can assure you it is. I would ask you to look at the language. I would ask you to recognize that the same judicial standards and the same legal standards are required to seek a search warrant under House Bill 83 as they are across the board.
Okay, thank
I would
you.
urge support of House Bill 83.
Thank you very much. There's one last witness in this panel.
Good afternoon, Chair and members of the committee. My name is Erin Earp, and I'm a senior policy attorney at the Giffords Law Center to Prevent Gun Violence. I'm also a resident of Calvert County. Currently, Maryland law only permits judges to order firearm relinquishment for temporary domestic violence protective orders in certain limited circumstances, but in no case does the law require relinquishment. This bill would require relinquishment and prohibit possession of firearms for the duration of all temporary DV protective orders, which aligns the prohibition for temporary orders with that for final orders. To grant the temporary order, the judge must find reasonable grounds to believe the petitioner or other person eligible for relief has been abused. While these orders are often entered ex parte, prohibiting firearm possession after an ex parte DVPO hearing is not new and has withstood due process constitutional challenge. 10 states require relinquishment at the temporary stage. 3 others do so in certain circumstances. In State v. Poole and State v. Rump, courts use the balancing test laid out by the Supreme Court in Matthews v. Eldridge to find that the state interest in protecting the victim outweighed an individual's right in possessing the firearm until the next hearing on the matter. The bill also complies with Second Amendment standards as articulated by the Supreme Court in Bruin and Rahimi. Rahimi stands for the proposition that the state can prohibit firearm possession for individuals who pose a physical threat to another, which is what this bill does. And finally, the standard here for temporary protective orders, namely that a finding of abuse results in a firearm prohibition, is already the standard for final protective orders under Maryland law. This bill will save lives, and I urge a favorable report. Thank you.
Thank you. Thank you. Any questions for this panel? Delegate Carton.
Thank you very much, Madam Vice Chair. Thank you for bringing the bill. And I have a lot of sympathy and interest in this legislation. It's good. I just want to make sure we address some of my concerns. So you the young lady on your right, our left, who just spoke last. you did a good job of making sure that constitutionally we're okay, and with an ex parte hearing that we don't have Second Amendment issues, and I think that I'm okay with all that. In fact, I love Bruin, right? So we gotta figure out how to deal within, or dealing with Bruin, I should say, not love it, but dealing with Bruin. And I'm no friend of firearms. I'll make that very clear. But when I am dealing with a defendant, this is not a criminal matter, right? And so maybe I'll address to Ms. Feinstein. I'm mostly concerned that if the person has to give up their firearm, that they're given notice, they're not necessarily at this hearing, so that they can do it without being forced to by a search warrant or having their lives interrupted, especially if they're willing to do everything they need to. And if there's no notice and they don't know about it, and they don't even know necessarily that the hearing is happening, are we disrupting people's lives inappropriately when we don't know if they're necessarily a threat, and all we have is the testimony of one side? I'm just worried that we are setting up a situation where we are, where we're essentially determining people's guilt before their family, before their friends, without giving them the opportunity to do what they need to do if it's to relinquish the firearm. That would be my first question. And my second question, are we giving any additional money to the local authorities who now are going to have a mandate to have to go in and find these people because they don't have notice, so we have to go out and find them, and it's only 7 days. We're talking about 7 days, and they have to do it basically within, we wanted to do it, I guess, that day, right? We want to go and get those firearms that day. So if I'm not making sense, let me know, but I just am more concerned about the actual practicalities of it versus whether, I agree that people who are abusers should not have firearms. I agree with that. I just want to make sure that we're not setting ourselves up for additional costs and additional problems with creating unnecessary negative energy.
So good afternoon again.
Good afternoon.
Just to speak to the notice issue, the individual has to be served with a temporary protective order to get that notice. It's not like they're supposed to know somehow that it's out there. That's already part of the process with respect to a temporary protective order. The temporary protective order is granted, it has to be served on them personally, or if they can't be served personally, at their last known address by mail within a certain amount of time. That provides the notice. So there is notice. I guess I would address that first.
The way I read the legislation, maybe I'm reading it wrong, is that you had to, as soon as the order is in place, not when the notice is given, but as soon as the order is in place, it's illegal for the person to possess a firearm.
No, Delegate Cardin, the whole process now, the temporary protective order does not go into effect until it is served on the respondent.
Right.
At that time, you hope that law enforcement is going to say, and if you have any guns, you need to surrender them to me now, please. So that's when they hear about it. It does not go into effect until he or she is served.
That is not how I read it. So thank you very much. That gives me a lot of comfort. How about the money issue of if we're going to be requiring, this is maybe for you, Madam Chair, we're going to be requiring the police to do a lot more work here because there's a lot more temporaries than there are permanents that are out there. And so they're going to be out there having to either do searches and seizures or following up because they find out that the person has firearms even though they said they didn't, or they forgot to ask them the first time they came to the house and served them, or I'm just worried that we're going to be stretching our local authorities too thin.
Well, thank you for asking that question. We, in fact, have been working with our local police officers. We've been talking with them. But even more importantly, in the fiscal and policy note, the information of the sources here are various county and state police. And the amount is not, I won't say nominal because everything is relative, but it's only $86,000.
Okay. Thanks. Thank you.
Thank you, Madam Chair. And thank you, Madam Chair, for bringing this wonderful bill. I just have a question for our prosecutor, Ms. Feinstein. You mentioned the search warrant issue, and I just wanted to give you a chance to flesh that out a little bit more. This bill obviously doesn't change the standard for a search warrant, and as I read it, it just directs the law enforcement to work with the state's attorney's office to determine if a search warrant would be appropriate, and then, of course, all the normal legal standards would exist. But could you mind addressing that?
Sure. We have to have the police have to have probable cause in order to receive a search warrant and to execute a search warrant. So first they have to have the probable cause to apply for the search warrant and in order to even draft the warrant. If they don't believe that they have probable cause, then they can't draft the warrant at all. So say they believe they have the probable cause and then they draft the warrant, and then it still has to be approved by a judicial officer to get the warrant. So we're looking at a bunch of stages of approval. So it's not in a vacuum. It's not that they decide that they want to go in, they think they have enough. The judge has to actually approve it, sign off on the search warrant. The same exact process is followed now for extreme risk protective orders. This already exists under that statute. And I know that in my county, the sheriff's office is executing those search warrants. I wouldn't say frequently. It's happening, but really the goal of this is so that we're going to have voluntary turn-in of firearms and that it's done right in that first moment, as Ms. Ruth said, when the temporary is being served. We already know that in many protective orders and many temporaries, we already are seeing surrender of firearms ordered. Just right now, it's a may, not a shall. And we're looking to move that needle given the statistics and the nexus to lethality. Thank you.
And I guess my first question is kind of along the lines of my colleague here, but I thought I read and understood that a person would have to, I guess, submit or turn over their firearms once the protective order is filed. That's what I thought I understood it to be, so you're saying no. So it has to be the warrant is issued and the protective order is issued? No. And, okay.
No, I'll try and do the brief how this works. If a petitioner goes to the court and seeks a temporary order of protection, there is a hearing. If a judge finds by preponderance of by reasonable grounds to believe that abuse has occurred as defined by the statute, the judge issues a temporary protective order. In current law, a judge may, but not shall, order the surrender of firearms at that point. And then, as I was saying to Delegate Cardin, when they serve the respondent, that's when it goes into effect, and if firearms were ordered surrendered, that's when they would try to effectuate that. So it does not happen when I walk in front of a judge to get my temporary order. It happens afterwards. And then, you know, currently 7 days later, but we are going to have a bill with Delegate Simpson that's going to try and lengthen that time. There's a final protective order hearing, which right now under law requires surrender of firearms. But the bill is a recognition that there's no teeth behind this to require respondents to comply with a court order. I mean, to me, that's part of the strongest reason to do this is that we have a court order, and as a lawyer, that's important. And the respondents are expected to just sort of voluntarily give their guns, and if there's no follow through by law enforcement, it's not happening. And it's not just in Maryland. This is true everywhere, and I believe that Ms. Herons gave you all a chart of other states that are doing required surrender at the temporary protective order stage, but they also all have current mandatory surrender at the final. Mm-hmm. So it's a process. It doesn't happen just out of the blue. It happens when they have notice, which is when they're served, that they have to surrender the firearm.
Okay, so this just makes it more of a requirement rather than.
It's really to give, it's to, how can I say this politely? It's to encourage law enforcement to follow through with a court order that says you must turn over your guns. And remember, it's temporary. The gun surrender is only until the order is not in effect anymore. Okay. So there are provisions in the bill that also educate the respondent about how to get their guns back if they have surrendered them.
Okay. So then on page 2, under line number 6, it says the person eligible for relief is a resident of the state regardless of whether the abuse is alleged or to have occurred in the state. And when I read that, it stood out to me that I recently had a father that I worked with who was falsely accused of domestic violence or abuse. So what happens when someone is accused but they haven't been found guilty? Or is there protection against people who are falsely accused?
Well, that's a whole nother bill that's going to come before you. And I can't remember whose bill it is right now, but it's about false statements. I mean, you know, when you're in front of a judge, in this case, we're not talking about in front of a commissioner, but in, you know, when I'm in front of a judge, I'm under oath to not commit perjury or make a false statement, which is a criminal charge. So, so there is ramifications of that if the state's attorneys follow through and pursue those charges. I can't tell you what the statistics are for that. And yes, it is unfortunate that people come to court and lie. I fully acknowledge that.
But, and also keep in mind that I think you're at 2, and then I think that's the section you're at?
Yep.
Okay.
Second page up.
So keep in mind that the standard for a protective order is that you are in fear of imminent bodily harm. That original abuse might have occurred outside of the state, but we as the state of Maryland have the obligation to protect individuals once they get in this state. So even though the original abuse might have occurred outside of the state, but if the abuser is still threatening and you know, if the harm would still occur here in the state of Maryland, that gives us the ability gives our courts the opportunity to issue the order. And also that is language that's already there. We're not amending that in this bill. Yeah.
All right, thank you.
And thank you, panel, for being here today, and thank you to our chair today. I did have a question on, a couple of questions and a couple of, first has to do with the fiscal summary. You touched on the state police component of why their dollar figure is. I just wanted to clarify, state police do not serve temporary protective orders. So that's actually a programming cost. But I am concerned about, as the good delegate said, about the imposing of a mandate on local government because it's a potential of a significant financial and operational impact on our locals, for our sheriff's offices and such. And temporary protective orders, unless something has changed, they're good up to 7 days, correct? That is still in effect. So literally, one of these can be issued and can be served, and their court date could be the very next day, correct? So I'm trying to think, if he or she is served, how would we comply with this if you're law enforcement to confiscate what could be, and I've done these because I've served them, 35 firearms, and then not be granted a final protective order and then return them within 24 hours? It just seems, I'm kind of asking how that's going to work.
Well, keep in mind, there's a couple of options too. They do not necessarily have to return it over to the police. They could actually give it to someone else and complete an affidavit. Am I correct, panel? Okay. Yeah, if it's a proper transfer, they could do a transfer with someone and provide the paperwork to the police, and thus saving the police having to do that.
So, I apologize if I did not see that, but in this bill, if someone is being served with a temporary protective order, and we are talking about temporary, we're not including interims, correct?
That's correct.
Okay, so as a temporary, I am served, and I would have the option to, say, five firearms, sign those over to a third party?
Yes, as long as you do a transfer within the law, a proper transfer, yes.
Again, what could be for 1 day? Could be.
Could be.
Could be. And my last question is, because the ex parte part of it does concern me, do we know how many ex partes do not become final protective orders, like a percentage in Maryland in a given year, or either dismissed, withdrawn, kind of like, in a general terms? I'm trying to get an idea. I know we love statistics. How many just simply do not become final protective orders?
I don't know if we really know that. I know that we have statistics that say essentially, and this is super ballpark, but about half of all petitions end up in dismissal or denial. So courts are doing, so that just an indication that courts are doing their jobs to evaluate, but it's not really, that they're not really breaking it down when you're looking at those into what's interim, what's temporary, and what's final. So I'm not sure we know those numbers.
Exactly, but it's fair to say that a large portion do not become final protective orders. Is that an accurate?
I think that's fair.
Okay, thank you. Thank you, Madam Chair.
Let me just make one more clarification, if I may, with respect to the interim. We do have an amendment, because there is one section in addressing the judiciary's informational paper. There is one section where we forgot to take out the interim protective order, and so we are striking that and making it comply with temporary only. Yeah, so you might have seen that.
I think it was a drafting error, not intentional.
Not intentional, no, no.
Thank you, Madam Chair.
Thank you, Delegate Valentine. Delegate Conaway, and then Delegate Woods.
And panel for coming to testify. Does a proper party mean only a firearms dealer? Is that?
No.
It could be an average citizen?
Yeah, you can transfer to an, you can transfer. Yes, as long, yes.
You could transfer your firearms to the average citizen, whether or not they're disqualified from.
No.
No.
So
They would need to be illegally or illegally allowed firearm possessor.
Okay. And does this include ammunition? Would ammunition have to be turned over?
I believe the bill does address ammunition. Give me 1 second. Do you agree? I believe I saw that in this. I believe we put that in. But just give us 1 second to confirm. It's been. You said no?
I don't think so. No, it's a gun and a permit if they have it. I'd be happy to add that.
And, okay, so if you do add that, will the ammunition be returned if the firearm is returned? No, it's not. Currently, it's not.
We can, when we consider that amendment, we can consider that as well.
Thank you very much.
Thank you.
Delegate Woods.
Delegate Conway actually answered my question. I wanted to get clarification on who that transfer could go to, but they have to be legally be able to own a firearm. And is that person somebody that has to be in the state of Maryland to be able to show that? So anyone that legally owns a firearm in any state can take a transfer? Yes, no?
We believe the answer is yes.
Okay.
If there's anything that's to the negative of that, I'll go ahead and make sure we supplement the record.
Thank you so much. Thank you, Madam Chair.
Thank you. That concludes our first panel. Oh, one more question. Delegate McComas.
Thank you, Madam Chair. I'm kind of concerned because the question is with a temporary protective order. That's what we're talking about to start this off, not an interim. Okay. So basically, can the parties still be in the same house and they have to surrender the gun? I assume not, correct? In other words, let's say the judge says, hey, things are fireworks, but it's not concerning enough to say, hey, dude, you got to get out of the house until we get him served. And
I suppose that there are orders out there, although I, in my almost 20 years experience, don't recall having one, that they said, I'm going to grant you a temporary protective order, but not require that person to have a stay away, no contact. It's almost, I can't recall a time that I ever saw an order like that.
They will say stay away until we have the interim.
I mean, because the primary goal is safety. So to me, if a judge was like, well, it's bad enough, I'm going to issue an order, a temporary order, I don't know what it would say if it's not stay away, no contact.
Well, my question is okay, if they're not going to be in the same house at the same time, okay, and he's not to, as soon as he's served, he's not supposed to be there, okay, if he would go and, I'm assuming he's not carrying his guns on his hips, okay, that he would have to go in and get the guns, okay? So the point is, wouldn't it be better to serve, to demand the surrender of the guns after it's decided that he needs to stay out of there for the interim or the final protective order, or the interim, so there, because this is, you know, it's temporary until they actually both get to court.
Well, I have two things. One, I think you're using the term interim in the non-term of art term of an interim protective order. You're saying between the temporary and the final, wouldn't it be easier to not make him surrender them? Is that essentially?
Well, if they're not, if they can't cohabitate and he can't get into the house.
Yeah, I think that is the primary thought that comes to mind with this bill. But the facts are, and the statistics are, and all of the research shows that that is the most dangerous time for the victim. And so it may be somewhat inconvenient. It may be, you know, I don't know, it may make people angry to have their guns removed, but that's the time when it's the most dangerous. And if you look at our statistics from 2024, you will see that in many of those cases, the victim, the homicide victim, had just left the relationship, just like Ms. Feinstein said. So when we're weighing in this community what's more important, we're weighing the life and safety of the victim over an inconvenience. And I'll also say this, when a respondent is told to vacate and stay away in the temporary, there's provision in the law for them to be accompanied by law enforcement to go into the house to get their necessities. And so it's a perfect time for them also to get their guns and hand them over. Law enforcement is there at the, you know, with them when that happens.
But the other concern that I have is, okay, let's say they are ditching the hubs, okay, and they get the initial order where you want the guns to be removed. There's other ways. You could burn the house down. We have women that have been stabbed. We've had women that, you know, they might blow them up. God knows what they're going to do, or take a kid. I guess what I'm saying is that if somebody is really mad at you and they really want to get you, they're going to get you. And when I've ever had clients where things are kind of scary, I tell them, okay, you got a piece of paper, it's a piece of paper. But I've seen women come in here that have had their arms thrown acid, and the guy went to the place of work and threw acid on him, and half their arm was gone. And I guess what I'm concerned about is that we may be giving women a false sense of security in their home because the guns are out, but that doesn't mean that the guy's going to get them some other way when they're that angry. And I mean, there are situations where we got some really bad hombres out there, and they want it, you know, it's like, you know, kill them and suicide or whatever, and we've got those cases out there.
Absolutely, Delegate McComas. Yes, we do see that. I think what this bill aims to do, when we look at the statistics of how many of these situations involve firearms, while we may not be able to solve the entire problem, this is solving, I think, again, in the report that Ms. Ruth has been referencing, in 2024, 63% of the offenders used a firearm in the fatality, the domestic violence fatality. So if we're talking about 63%, that's 63 out of 100 people that we've gotten their firearms taken away from them during that time period. Now, of course, they could go get an illegal firearm. They could get, you know, acid. They could get, you know, materials to commit arson, of course. And unfortunately, my office sees the end result of that when those cases are, you know, prosecuted potentially. We can't, this bill is not going to solve domestic violence for sure, but it's going to address that 63%. And I think that's why it's so important.
I'm still worried about the fact that they may feel that they're safe and they're not.
Right.
And I would always tell them, hey, you got a piece of paper, and that's not going to stop him coming through the door. I don't care if he's got guns, knives, whatever, it's not going to stop it. And I think that I don't want to give women or the public a false sense of security, because the bottom line is that you know, if somebody's going to go after you, they're going to go after you.
Well, and that's why safety planning is so important. A temporary protective order shouldn't stand in isolation. I know in my county that there are services immediately offered to individuals who seek a protective order, a temporary protective order. They're met at the courthouse by individuals from our Family Justice Center and the Sheriff's Office to provide and offer that safety planning. We're rolling out in my county, actually, at the end of this month, training for family law attorneys around the lethality factor, so that safety planning can go hand in hand with seeking a protective order, because it definitely triggers separation or termination of the relationship sometimes when protective orders are sought, and that safety planning needs to go hand in hand. I completely agree with what you're saying. And I'm sorry, did I cut someone else off? I apologize.
I was just going to add that it's part of the bill as well, the safety planning.
I just have one question. You said it's what, 63% that it's weapons that are, you know, firearms that kill or harm the victim. How many numbers-wise is that 63%?
So I'm looking at the stats from 2024. 32 Maryland domestic violence victims of domestic violence were killed by their abusive or current or ex-spouse or current or ex-boyfriend. That's not including bystanders. That's not including children. And so it's 63% of that 32. So, and that's the Maryland stat. I believe I'm stating that correctly.
And the chart is attached to my testimony, so you can read it for yourself. And it is broken down by bystander, children, homicide, suicide. I mean, one of the things I'll just say that never gets talked about here is suicide. And I'm sure Delegate Cardin knows, in Baltimore County, we've had an epidemic of murder-suicides. I think if most of them with guns in the past 6 or 8 months. It's been really horrific in Baltimore County and inexplicable in some ways. But don't forget, there are also the suicides that happen.
Colleagues, we have at least 2 more panels on this bill. I'm not going to ask you to limit, can you just limit it to at least 1 question at a time so we can get to the other 2 panels? If there's no objection? Delegate Valentine.
Oh, I don't think she's.
Thank you, Madam Chair. I apologize. I typically don't ask a second question. This one has to do with those that, as part of their employment, I'm talking about security officers, law enforcement. How is this going to look if this is implemented for those individuals? Say they, again, an ex parte hearing, they have no idea this is coming. They're served with a temporary protective order that could be good for 1 day, and now they can't go to work tomorrow. For a day or 2. How is that the intent of this as well?
Yes. Yeah, simply yes. Yes. If the standard is reached, the judicial officer decides at the temporary protective order, then yes, they're not exempted.
Okay.
Thank you. Last question with this panel is Delegate Boucher.
Thank you, Madam Chair, and thank you, Madam Chair, for bringing the bill forward, and thank you for this panel for having such concern for people's safety. Usually these protective orders are coupled with a criminal assault charge. When that does happen, is part of the bail and a release condition that they surrender their firearms? Is that already a mechanism in place that gets utilized?
I can say typically yes. We would be asking for that at the bond hearing on an assault case. But I would also say that, at least in my jurisdiction, it's not always coupled, together, that a protective order is sought and a criminal charge at the same time.
Is there a percentage of how many of them are coupled with a criminal charge?
I don't know that I could speak to that.
Okay.
I just know that the numbers that we have of temporary protective orders that are sought are definitely considerably higher than the number of second-degree assault cases we have that are domestically related.
All right. I was just wondering if that's a tool that can be utilized, so thank you.
It can be when those charges exist.
All right.
Appreciate it.
Thank you to this panel. I'd like to call up the second panel. I have Lydia Watts, Kelly Sampson, Spencer Cantrell, Catherine O'Malley. Is that 5? And Eileen Zeller. Okay, who we're missing?
Madam Vice Chair, Madam Chair, excuse me, Madam Chair, Vice Chair. I don't know if there's anybody virtual, perhaps? Because I know you called more names than 3 of us.
Well, I have more, so let's add some more.
Kelly Sampson's virtual.
Okay, well, she's not signed up as virtual.
Oh, we didn't see Lydia.
You gonna preside over it? Yeah. Is that fast?
Okay, so Kelly Sampson, I see you are there. We've got Spencer Cantrell. Are you, okay, there you go. And Aaron already, and Debbie, and Katie O'Malley, and Eileen Zeller. Okay. Lori Ruth. Is Nyla Jimenez here? Jimenez? Or Layla Gretton? How much? Okay, we've got our 5 plus one person on virtual. Do we have Taraya Stanley virtual? Okay, let's go ahead and bring her forward so that we can at least do our knock out this whole panel. Okay, whoever's ready to go first. Thank you.
All right. Good afternoon, Chair Bartlett, Vice Chair, and members of the committee. My name is Spencer Cantrell, and I'm faculty at the Johns Hopkins Center for Gun Violence Solutions. I'm also an attorney with experience representing survivors for a nonprofit in domestic violence protective order proceedings. And I'm here today in strong support for House Bill 83. I work around the country training law enforcement and other implementers on firearm relinquishment and improving these processes to support survivors. I want to speak today in particular to some of the due process protections included in domestic violence protection orders and what we're also seeing that's consistent with extreme risk protection orders. There are many instances in the law in which someone has a temporary deprivation of their rights before a hearing without the respondent present. In the protective order context, no one has their firearms removed until after a judicial officer has reviewed the petition and any evidence submitted to determine whether a firearm should be removed. This is consistent with what we see in Maryland's ERPO context as well, where firearms are removed from individuals threatening harm to themselves or others at the temporary stage. I will also note that in ERPOs, there is firearm removal at the interim stage. There are also other situations in our country where we have determined that it is important to act and grant immediate relief in order to protect public safety, even when it might be inconvenient. In emergency petitions, clinicians can detain someone for mental health evaluations for many hours without a hearing. If there's ever an instance of child abuse, CPS can temporarily remove children from a home or the custody of their parents and guardians before there's a hearing in order to protect the rights of children. What we're asking for in the protective order statute is consistent with how due process works in these other contexts, balancing an individual's rights as well as threats to public safety. I'd also like to note that in ERPOs, or extreme risk protection orders, we are seeing survivors filing for ERPOs and DVPOs concurrently in order to have firearms relinquished earlier in the process and ensuring that those firearms are in fact relinquished by the respondent. Ensuring that firearms are removed at the temporary stage would be a much more efficient use of judicial resources, as well as the survivor's time and the times of victim advocates, rather than having people file for multiple orders at the same time. I'll also note that research I've done around Maryland looking at when judges ask about firearms, judges are not inquiring about firearms at the temporary stage. And so this relief may not be granted when it's warranted. Thank you for your time.
Thank you. Good afternoon, Chair Bartlett, Vice Chair Davis, and distinguished members of this Judiciary Committee. My name is Katie O'Malley, and I'm currently the Executive Director at the Women's Law Center of Maryland, and we strongly urge a favorable report on HB 83. In a prior life, I was a judge in Baltimore City's District Court for 22 years, and I have to tell you, I have presided over thousands of protective order cases. One of the things that this bill, two things that this bill does that are really important that don't happen now, as you have all heard from the prior distinguished panel, takes the guns at the temporary stage, gets information at that temporary stage from the petitioner about the firearms, where they're located, how many firearms there are, if they're in a home or if they are potentially in a vehicle, getting all of this particular information can be vital if a final protective order, if that temporary protective order is then issued after the judge makes a finding of reasonable grounds. Because then after service of the temporary order, if the gun is not surrendered, law enforcement then has a process that they can follow. Right now, there is no process. And so after serving 22 years and seeing some really horrible tragedies throughout our state and our country when it comes to gun violence, I can tell you that this goes a really far, far way of establishing that process so the guns can be surrendered in a safe manner, protecting families. I remember a story back when I lived in Annapolis of a young woman who got a temporary order from the district court, and between the temporary, even though the guns were ordered, because they may be ordered by the judge, the guns weren't surrendered. And between the time that she got her temporary order and went to the final order, he had violated the stay away, had gone to the home, and was threatening to kill her with his firearm. Fortunately, long story, but fortunately, law enforcement was able to get there. Sadly, he died. He was killed by the police because he had a gun to this woman's head and was going to kill her and then kill himself. So it's really, really vital that we pass this law, and I thank you for the opportunity to appear.
I'll go next. Good afternoon. My name is Eileen Zeller. I live in Howard County in District 9A, but today I'm testifying on behalf of my friend Nicole. Nicole is a professor in the University System of Maryland, a researcher, a Wicomico County resident, a gun violence survivor, and a parent. These are her words. My ex-husband, during one of his blackout drunk moments, held a gun to my 9-year-old son's head. After we separated, he started breaking into my house while armed. Ultimately, I received a restraining order. But when the judge ordered him to turn in all of his firearms, he surrendered only one, despite having an arsenal. There was never any follow-up from law enforcement. Trying to disarm my ex-husband while he was an imminent threat to me, my children, and himself made me realize how vital it is to remove the guns from DV situations before they can turn deadly. Guns are tools of intimidation and control in abusive relationships, often used to terrorize victims long before a trigger is pulled. Survivors fleeing domestic violence face many barriers, including inconsistent enforcement of firearm prohibitions for abusers. That gap puts lives at risk and leaves families unprotected by the very systems meant to keep them safe. There should be no ambiguity when someone who poses a danger is legally prohibited from having guns. Intimate partner violence and gun violence are closely linked, and the presence of a firearm makes a lethal outcome far more likely. When a protective order prohibits firearm possession, all firearms must actually be surrendered, and the courts and law enforcement must ensure compliance. Follow-through is not just optional, it is life-saving. We urge a favorable report on HB 83.
Thank you. And before the next person begins, could you give me your name, please?
I apologize, Lydia Watts.
Okay.
This is my panel, but I was
No, that's fine. Ms. Watts, let me just say, we usually prefer to have 5, and the reason for that is because of the camera angle. So could you just step back, and you'll be on the next panel?
Perfect.
Okay, thank you so much. Yep.
Good afternoon, Chair Bartlett, Vice Chair Davis, and esteemed members of the House Judiciary Committee. My name is Layla Gretton, and I am here today to voice my support for House Bill 83 on behalf of Team Enough Baltimore. I'm a high school senior and the founder and president of Team Enough Baltimore, a youth-led chapter dedicated to gun violence prevention under the Brady campaign. As the president of Team Enough Baltimore, I oversee nearly 50 students with a shared passion and commitment to gun violence prevention. In the U.S., 4.5 million women report being threatened with a gun by an intimate partner, and nearly 1 million have been shot by an intimate partner. The presence of a firearm in a domestic violence incident increases the likelihood that a woman will be shot by 5 times. And survivors in Maryland face the same risks due to a gap in firearm relinquishment protocols. The Family and Law Enforcement Protection Act addresses these gaps by ensuring firearms are relinquished or removed earlier on in the stage of a protective order, and would provide extra protection in these high-risk scenarios. In these situations, it is not only the victims who suffer. The children in these households are just as much at risk. Being exposed to that cycle of violence at a young age can increase the risks that children grow up to repeat acts of violence and abuse themselves. Not only does that trauma that they experience last with them for a lifetime, but often it is the children themselves who end up hurt in these situations. They are often at increased risk, of developing PTSD, depression, or other anxiety disorders. Furthermore, it is proven that children who are present when domestic violence takes place are more likely to be killed and injured. In situations of physical abuse towards a mother, there's physical abuse towards a child in 1/3 to 1/2 of the cases. This bill is vital in protecting survivors of domestic violence, their children, our communities, and our families from gun violence. Abuse that takes place after a protective order has been filed can be prevented, and therefore I strongly urge a favorable report for House Bill 83. Thank you.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the House Judiciary Committee. My name is Nayla Jimenez. I'm a high school student, and I'm a member of Team Enough Howard County, a youth-led organization dedicated to preventing gun violence. I'm here today to share my story and to urge you to support House Bill 83, Family and Law Enforcement Protection Act. This bill requires an earlier surrender of firearms when a protective order is issued. Currently, protective orders move through an interim, temporary, and permanent stages. During this time, abuse can escalate, and access to a firearm can turn a dangerous situations into deadly ones. House Bill 83 closes that gap by removing guns earlier when emotions are highest and risks are greater. I know why this matters personally. Growing up, my father struggled with alcoholism. At first, it showed through aggression and sleeping all day, but over time, it became verbally and physically abusive. My mother and I were screamed at, accused of things we didn't do, and lived in constant fear. I remember him punching holes into walls, breaking furniture, and one day when my mother tried to walk away from him, he grabbed her scarf and choked her. For a long time, one thing that made me feel safer was knowing that there was no gun in our home. That changed one morning when he pulled off to the side of the road and he showed me the handgun he had just bought. From that moment on, I lived on edge, afraid that one wrong move could turn deadly. If we had filed for a protective order because we never filed for a protective order because we feared of what might happen in those first critical hours. If we had, and if House Bill 83 had been a law, my family would have been safer. I share my story for the families still living in fear. This bill would protect them and save lives. Therefore, I strongly urge a favorable report for House Bill 83. Thank you.
Thank you. And now I'm going to change my mind. Your Honor, if you could just move over to that side just a little bit. And then if Ms. Jimenez, if you could just move over, no, the other way. I want to bring Ms. Watts up, is where I'm getting at. Yeah. Whichever way Ms. Watts can fit in, please. It is a dance move. You're right. Yes. Okay, and Ms. Jimenez, I want to make sure you're still there as well. Okay, great. And I apologize, Ms. Watts, but no problem. I'm looking at the totality and it makes sense. So if you could go ahead and present your testimony, please.
Absolutely. Good afternoon, Chair Bartlett and members of the Judiciary Committee. My name is Lydia Watts, and I am the Executive Director of the Rebuild, Overcome, and Rise, or ROAR Center at the University of Maryland, Baltimore. I'm here today in support of HB 83, the Family and Law Enforcement Protection Act. ROAR provides comprehensive wraparound services to survivors of violent crime in Baltimore City, including providing trauma-informed legal advocacy. Since 2019, we have served more than 900 survivors of homicide, non-fatal shootings, sexual assault, and intimate partner violence. Many of the survivors we serve have been threatened or harmed with firearms by a current or former intimate partner, most often during separation or while a protection order case is pending. HB 83 directly addresses a dangerous and well-documented gap in current law. The bill strengthens firearm surrender requirements in protection order cases and critically requires local law enforcement to act within 3 business days when a respondent is not in compliance with the firearm surrender order. HB 83 supports both officers and survivors' safety by providing clear statutory direction and a defined timeline after service of a court order, reducing ambiguity in some of the most volatile calls officers respond to. HB 83 does not mandate broad or prolonged firearm storage. It applies only after a court order, allows prompt return if no final order is issued, and reduces repeated crisis calls that often strain police staffing. It also provides a temporary and well-defined compliance action. From a fiscal perspective, HB 83 shifts law enforcement time from unpredictable, high-cost emergency responses to a defined court-triggered compliance process that is far more efficient and far less dangerous. With that, I respectfully urge the committee for a favorable report on HB 83.
Okay, committee, I do not see any indication of questions, so I'm going to move on to our virtual panel. I'm not going to close off. Okay, you've got a question? Delegate Simpson.
I was like, I thought we were waiting until you finished the whole thing. That's why I didn't turn on my.
Right, that's fine. I was going to just, if you have any questions for this panel, and then we'll move to the virtual panel.
Okay.
Are you ready?
Yeah.
Sure, go for it.
So, Judge O'Malley, I know that you have an extensive experience. Can you give us some examples of how this bill could have been helpful and have made a difference?
So I think, again, hearing from the other panel, getting firearms taken from the abuser when firearms exist in an intimate partner relationship situation quickly and safely is the best policy. So right now, the law says that a judge may require that the firearms be surrendered, but it doesn't have a process for how that happens. So in the situation where I explained my friend who was, a survivor, she had gotten the temporary order. The judge did say that because she told the judge that her husband had multiple types of firearms, and he did order that not only that he vacate the home, that he have no contact with her, that he surrender these firearms. There was no process for how that would happen. And on the day of the final protective order, so there was a whole 7 days had gone by. She's at her final protective order, trying to leave. When he comes into the home, has his firearms still, because he hasn't surrendered them, doused the entire home, this was in Davidsonville, with kerosene, was going to light the house on fire, kill her and himself. That was his plan. She was able somehow to get a signal to a friend that she sent 911 on her phone, and then it was turned off. The police were able to then come quickly, saw him through this glass door with the firearm, and the police were able to shoot and kill him. If there had been a process, and this, again, because we didn't have this in the law, if there had been a process where then there could, like this bill allows for, then those guns, there could have been a process for a law enforcement to get a search warrant from a judge to say, because it's within 3 days, if there's not a surrender, within 3 days, these firearms haven't been relinquished, present that to a judge, get the search warrant where you believe those firearms are. She believed they were in his vehicle, and that's exactly where they were found. So that, to me, is an example of how we can be saving lives with this swift and quick way of getting firearms taken when they are known to be in an abuser's hand.
So this is, the premise of this bill is taking the information from cases that we have seen and that we know from both from Maryland and elsewhere, and trying to put into the code things that we know would have made it, that we see happen, such as this, saying, look, they knew where it was and could have told them, and instead of one gun, could have gotten all the guns or most of the guns to keep somebody safe.
Because there is no process right now for this sort of, but this bill provides the process, and I think that's really important, and it makes what all counties do across the state more uniform as well.
And as someone who, as a child protective services worker, I was called to a house to go get the kids because he had just shot the mom, killed the mom, and he was threatening to kill the children and himself. And so we did get the children out, and then he did shoot himself afterwards. But as someone who has actually seen that, and of course that's back in the 90s, so I do appreciate, Chair, that we are taking a proactive approach.
Isn't that so?
Isn't that so? I did ask a question.
You did. You did.
I did.
Thank you. Delegate Ericon.
Thank you, Madam Chair. Thank you all for being here and sharing your stories or your friends or family's stories. I have like a very kind of random question. Just her question kind of led me down this. For any of the victims, were they themselves personal firearm owners by any chance? Like, did any of the female victims in these cases have their own firearms? I'm just trying to, we never find out about that in these cases, and I always wonder if there's any deterrent effect at all.
My friend did not. I'm certain in the world that there are petitioners who may have firearms. In 22 years of sitting on the bench, sometimes they're to law enforcement.
Okay, so there, in that
People will
case, there
come,
would
so there'd be
be.
a law enforcement petitioner versus a law enforcement respondent. Sometimes you would see that situation. This bill clearly doesn't require that the petitioners surrender or have any.
Well, that's good.
Right.
Oh, Lord, yeah, that would be
There's no
bad.
suggestion of that
Yeah.
in this, but yes, I'm sure there have been.
Okay, but it's not super common. In none of the other cases were the women firearms owners or wear and carry permit holders? Okay, all
No,
right.
if I may, I've been in the judge obviously has far more experience than I do, but I've been an attorney for 30 years representing survivors of intimate partner violence, and I would say the vast majority of the survivors I served knew that the respondent had firearms, typically unregistered firearms, and they themselves did not. So they did know, like Judge O'Malley's friend, where the guns were stored, if they had, again, if there was a process to get that information, either before a judge or to the police. But what we hear often when we're asking that of the judge or the police is, well, he says he doesn't have it.
Right.
So then,
Right.
there's no.
They just take him at his word because he's the shining example of a citizen. Yes,
Exactly.
I'm very familiar with that vibe. Thank you, guys.
Thank you. Delegate Stinnett?
Yes, thank you, Madam Chair. I think this bill is very important and very needed. My concern is that, or at least my question is, what are the outreach efforts to make sure that, women or even families know about this bill? Because I know that just listening to my colleague, Delegate Simpson, that I know that I've been abreast to a certain situation. Husband murdered the mother and the daughter, dealing with post-traumatic syndrome as far as from the war and stuff like that, crawling around the room and thinking that he was, still in war. But I think that, my issue is, or at least not necessarily my issue, but just making sure that folks have the understanding that they can move forward if this bill is in place and so forth. And just like you had mentioned that if this bill was in place, it could have prevented something, could have prevented the whole situation.
Well, if you pass it, we'll make sure that the word gets out. You do your job, we will definitely do our job.
Right. Yeah, thank you.
I would just add that both of our organizations do considerable outreach, as well as many others throughout the state. I think, that a lot of the barriers are things similar to what we heard from this young lady to my left around concerns, legitimate safety concerns. So I think if we were able to advertise this amendment to the law to allow people to know there is a mechanism for the gun to be seized, in a short number of days. So it is always an outreach issue. I mean, that's probably 3/4 of our job is letting survivors know that they can reach out to us for those types of services. But it will be a great addition to be able to add this revision if passed.
Right. Thank you.
Thank you. Delegate Phillips?
Thank you, Madam Chair, and thank you to the panel. I am a big proponent of responsible gun ownership, and also a big proponent of making sure that we keep people safe. And I think each year I've tried to figure out something in this area to focus on. So I want to thank you, Madam Chair, for bringing this bill. I am concerned on the logistics of how this will really work. In my past dealings, I've seen that often with temporary orders, they're not, the person is not served in a timely manner. Our system, this system is not the most efficient. And so while we do this, I'm just concerned that it may not yield the results that we would like it to yield because we just have an inefficient system as it relates to serving these temporary orders. So, Judge, could you talk about that, and it's good to see you.
Thank you. It's great to see you too, delegates. So service has been an issue for many, many, many years. Now with the creation of MDEC and the judiciary is 100% now up to speed with MDEC. So all jurisdictions are on MDEC. Baltimore County just implemented, because they were having some pretty serious service issues, implemented a new policy with the Baltimore County Police Department that I was very, very happy to see, where the orders now, once they are entered into the system by a district court judge or a circuit court judge, well, the sheriffs are a different story. So for Baltimore County Police in the district court, those orders are then put in to the system electronically by the judiciary. And then that way they are in real time when they are being issued, are getting notified to the police department that there is in fact an order that needs to be served. What was happening prior to that was that at the end of the docket, so say your docket starts at 9, it ends at 12, at the end of the docket, all those orders that a judge had ordered would be then sent to the districts for them to be then at evening roll call for the police officers to then manually serve them, but they were also doing their other duties. So they might get a call for a robbery or they might get a call for an assault. So those orders were in the back of their car, literally, and not the priority. So now with having the police department and the judiciary working together through MDEC, they're going in real time so that the police can get those orders. The precincts are assigning them, not at the end of a docket and not like at the beginning and telling them throughout the day to get served. The other good portion of this is that once they are in fact served, that is being electronically sent to the court as well, so that there isn't a situation where you'll see a petitioner come in and say, I know he was served or she was served because I saw it happen, but that physical piece of paper hadn't made it out of the officer's car and gotten back to the courthouse. So that has been what most of the jurisdictions in the state of Maryland have been following since we do now have MDEC, and it really is making a huge difference in Baltimore County. Their dockets are a lot heavier than they were before this implementation, which just started October the 15th. So you're right, that has been an issue. But this bill, that's sort of a sub-issue as to what this bill would do, because like, as you know from the other panel, as soon as that temporary order is issued, it doesn't go into effect until the respondent is served, and that's when it triggers the surrender.
Right, and that's kind of my concern about this process and just thinking it through. I haven't practiced in this area in a long time. So the next step, it is served. Let's say the police determine that this individual works in Towson. And so they serve this individual in Towson, and I suppose at that point, if we do this clearly, they would then ask to remove any firearms that they may have with them at that time. The police would then also say, do you have any other firearms, and then have to go to their home or to their office or to the other locations? Is that what the expectation would be?
That would be the best case scenario, because the order will say that the respondent shall surrender the firearms. So it's incumbent on that officer, the law enforcement officer, to say, here's the order. You cannot go to this home. You cannot have contact with this person. And one of the other remedies, you have to surrender firearms. There's credible information in this petition that you have these firearms and you have to surrender them. Now, what happens if the respondent says, well, I don't? I mean, then it comes down to an issue as to, is there enough information for that law enforcement then to seek a search warrant from a judicial officer?
Okay. All right, I love what this is doing. I'm just trying to think through the practicality and how it might work. And then my last question, Madam Chair, and I apologize, 'cause I really am, I like the bill and I want to figure out how to work through this with you. I have a police officer or another law enforcement officer, and I think Delegate Valentine started down this path, and he needs that firearm for his occupation, for his job. Is there any way for that individual to appear before a judge faster than maybe 2 days later or 3 days later to request a special hearing? Is there any provision for giving a judge some latitude?
No, there would not be. So there's no exceptions for law enforcement. So if it's taken at the temporary, then that law enforcement officer will not be able to have that firearm until there's a final hearing. If the final hearing, there's no preponderance of evidence that their abuse occurred, then he gets his firearm or she gets her firearm back. If there is preponderance of the evidence or a consent, then the firearm is taken for however long the judge issues the order, which could be 6 months, could be up to a year.
Okay. Thank you.
I'm going to go to Delegate Simmons, and then I'll go to Delegate Cardin.
Thank you, Madam Chairman. Thank you all once again for your testifying today. We really appreciate your patience with us as we try to get through this. Can you just give me an example? I'm listening to a lot of testimony, and I'm trying to see how this equates to our red flag laws. And are there, in your testimonies, there similarities in what y'all are saying compared to what we already have in place? Can you talk to me a little bit about it and whether or not that's relevant to the conversation?
Sure. So we're seeing firearms being surrendered in both protective orders and red flag laws. Very similar. We're actually seeing red flag laws being used in many domestic violence situations in Maryland. And so you have domestic violence survivors filing for a red flag law or an ERPO at the same time they're filing for the protective order to ensure that there's that firearm relinquishment. When you have a savvy survivor who's getting that safety planning advice, they'll do that. And I think this could be a way to make it more efficient to have one order to do what the red flag law would do in the protective order already embedded. But this is relief included in the red flag law. It's just not a great use of resources to have to go to court for multiple orders. Hard for the judges, hard for the survivors.
And I would just add to that, as an attorney that's done that on behalf of clients, because it isn't yet widespread, or at least in Baltimore City, ERPOs are not being sought in a widespread way, that it's still challenging for even an attorney to navigate, the clerk's office, understanding what we're trying to do and getting it scheduled, contemporaneously with the protection order. So without an attorney, I can't even imagine it happening at all. So again, just the burden on the survivor of not only having to file those two cases, but it's, navigating those two cases through, at least in Baltimore City, a system that's getting better, but still is not everyone's fully aware of how the ERPO process works, very well acquainted with the protection order. But if somebody is forced to do both, that can be very burdensome.
Yeah, I was just trying to understand the extreme risk protection in comparison to what I'm hearing. It seems like it's the same thing to me. So when I read it and then I listen to your testimony, I feel like we're talking about the same thing. But, I was trying to see, is this an idea of replacing that with stronger legislation, or is it running parallel to what, is it the work? Yeah.
It's running parallel because the protective order is for the survivor to file. Extreme risk protection orders or red flag laws aren't just used for domestic violence, right? They're often used for threats of mass shootings, threats of suicide. Over half of red flag laws or ERPOs in Maryland are filed by law enforcement who see a threat. Most of the other half is filed by family and household members. So this is not replacing the red flag law or the ERPO, but it is making it more concise for a survivor to get firearms removed in the protective order.
Okay, thank you all. Thank you.
Thank you. Delegate Cardin?
Thank you, Madam Chair. Thank you guys very much for coming and giving us your compelling testimony, especially the high school students. Very powerful. Really appreciate it. Your Honor, since we've had a number of cases together and dealt with some of these things actually on a professional basis, so it's good to actually hear from you, who you have more experience than probably all of us combined. If there's a consent order, can the judge allow in the consent with the consent of all parties for example, a police officer to be able to maintain his firearms?
No.
Okay, so would there have been
And that's already law.
I understand, but looking back in your, not in the work that you do now, but in your work as a judge, would there have been a time that you would have wanted some judicial discretion to be able to provide that, or you don't, or you appreciated not having judicial discretion?
Well, I appreciate it not, well, I can just say that, abuse can happen, and there are all kinds of professions. So law enforcement's not excluded. Sometimes, sadly, there are abusers that are law enforcement and have access to firearms. And generally, in Baltimore City, what I would see was that the department, once a temporary was issued, was in the courtroom watching at that hearing and making sure that the firearms were surrendered. And then they didn't, the officer did not lose his job. Obviously, she or he still had the opportunity to have the final. At the final, if the firearms, if there was a preponderance of evidence that abuse occurred and/or a consent, the firearms were taken. And then I would see oftentimes that officers were allowed to do things that did not require them to wear a firearm in larger jurisdictions. Now, that's probably a more difficult thing to do in a smaller jurisdiction, but in
I'm just
Baltimore
wondering
City, that's how that.
if the victim is okay with a separation and a no, but there's no way to do that, and there's no way, and that wouldn't be something that obviously you and your panel would be interested in.
It's
clearly.
very dangerous, I think, especially if, in fact, there's been a finding of abuse and there's been a history of abuse. And knowing that a registered fire owner is far more lethal to a survivor, like so many more times when you look at lethality assessment reviews, when you look at the fatality reviews that are done, also registered firearm owners and lethality are just very, very high.
Right. So if, I'm going to change gears a little bit, if you have a police officer who's going and trying to take firearms away from a respondent, and they miss one, or they didn't get there, they were supposed to go, they went the wrong time, or there was some either a mistake, misunderstanding, or decision that this is only going to be for a few hours because the hearing is at 1 and I finally got to the guy at 9 a.m., so I'm not going to bother until after the permanent. And then something happens. Is either the county or the individual on the hook for liability, for civil liability?
Well, obviously, that's all outside of what this bill does.
But this bill is opening it up to a lot more of that of exposure in that way.
Well, I mean, they're already in law now. We already, since I believe 2008 or 9, are giving judges the ability to take firearms at the temporary stage. So that's already there. And I haven't seen some situations where they're like, oh, geez, it's only 2 hours till the final. I'm not going to go get those guns. I haven't seen that actual scenario. But I think that if they are in this situation, if they're ordered, if the respondent's ordered to surrender the firearms when the officer is there and can get it done safely and efficiently, yes. If, I don't understand necessarily the question. If they don't do it, or if they miss one, are they going to be sued? Is that what you want to know?
Well, I would be, so the previous panel, there was a statistic, it was not an exact statistic, of approximately 50% wind up without a permanent, maybe even more, wind up without a permanent. So you're talking about this 1 to 7 day period where you're going to have for a vast number of people. And the question is, first of all, there's the cost benefit analysis, which you guys have made a very good case for. And then there's the other issue of, if we're opening up, requiring law enforcement to do a tremendous amount of work here, and if the work is not done for everything because of the workload, are we going to open them up to potential liability if there's a case where somebody is hurt?
There is case law that suggests no, or it's not Maryland, it's federal district court, if wherever, Colorado, whatever district court that's in. But Jessica Gonzalez versus, I think it's Castle Rock, Colorado. And the facts in that case were very, very egregious, where as a result of the police inaction of retrieving the guns, all of the children were killed by the abuser, and then he killed himself. And sad for the mom, left her surviving to spend the rest of her life grieving that terrible tragedy. She took that case all the way up to, I believe the Supreme Court denied cert, is that right? Or did it go to the Supreme Court?
I believe the Supreme Court ruled against her and said that law enforcement were immune from liability for that. I'll also just note, this is in a red flag law context, but this is a Colorado case from last year that was not heard by the Supreme Court, but that families sued the Sheriff's Department after a mass shooting for failure to file for an extreme risk or a red flag law, and the families lost that case as well. So I appreciate the question, but it's not something I have seen in the case law.
No, that's great. And again, thank you guys very much for your advocacy on this. Appreciate it.
Thank you, panel. That concludes this particular panel. We're going to move on to our witnesses who have been waiting online very patiently. Thank you very much. Kelly Sampson, we're going to start with you, and then we're going to go to Ms. Stanley.
Thank you, Chair Bartlett, Vice Chair Davis, and distinguished committee members. I'm Kelly Sampson, and I'm Senior Policy Counsel at the Brady Campaign to Prevent Gun Violence. Just want to reiterate that HB 83 will save lives without running afoul of the Second Amendment. In Rahimi, the Supreme Court found that the United States has a long history of laws preventing individuals who pose a threat to others from having firearms. That's why, as far as I know, all firearm surrender statutory schemes in the protective order context have survived Second Amendment challenges in the years following the Rahimi decision. Furthermore, these are not lifetime bans or status-based disqualifications. They are time-limited restrictions tied to adjudicative findings in a domestic violence proceeding aimed at preventing devastating tragedies before they can occur. In domestic violence situations, clarity and compliance can be the difference between life or death. HB 83 simply improves clarity and compliance procedures for domestic violence protective orders while upholding the constitutional rights for everyone involved. That is why we support this life-saving bill and urge a favorable outcome. Thank you.
Thank you. Ms. Stanley?
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Taria Stanley. I'm here on behalf of Community Justice. I'm also here as a survivor of intimate partner violence. I am alive today because my abuser did not have access to a firearm. That single fact is the difference between survival and death. Unfortunately, that has not been the case for too many women in the state of Maryland. When firearms are present in domestic violence situations, they significantly increase the likelihood of fatal outcomes. Studies show that the presence of a firearm in a domestic violence scenario increases the risk of homicide for women by 500%, according to the DOJ. For Black women and women of color, this risk is even more pronounced. Research reveals that women of color are more likely to be killed by intimate partners using firearms compared to their white counterparts. This stark disparity highlights the urgent need for legislation that addresses the removal of firearms in situations where this is documented abuse. In 2023 alone, 38 Marylanders lost their lives to intimate partner violence. 74% of those deaths were caused by a gun. 40% of the victims were Black women, meaning Black women were dying at 5 times their share of Maryland's population in intimate partner homicides. Firearms turn abuse into a death sentence, and Black women bear the brunt of that reality. House Bill 83 is a life-saving intervention. It ensures that when a protective order is issued, firearms are actually removed, not just prohibited on paper. Clear surrender requirements save lives by preventing moments of crisis from becoming irreversible tragedies. House Bill 83 closes that gap. It ensures that when a judge determines there is danger, firearms are removed swiftly and clearly before another family member loses a mother, child, or a loved one. For women and families across the state of Maryland, and for survivors like myself, I urge a favorable report on House Bill 83. Thank you so much.
Thank you. Members of the committee, do we have any questions for this online panel? Seeing none, that concludes the favorable testimony for House Bill 83. Now we're going to move to our unfavorable testimony, and we have online Mr. John Jocelyn. Hi, Mr. Jocelyn, whenever you're ready.
Good afternoon, Madam Chair, and congratulations. John Jocelyn speaking on behalf of 2A Maryland in opposition to House Bill 83. This bill may actually be counterproductive.
Hi, Mr. Jocelyn, whenever you're ready. Oh, Mr. Jocelyn, please turn off the YouTube video, or at least turn it down.
John Jocelyn. Are we ready now, ma'am?
Yes, let's go.
Thank you. Good afternoon, Madam Chair. John Jocelyn, speaking on behalf of 2A Maryland in opposition to House Bill 83. This bill may actually be counterproductive due to the amount of information it requires the person suffering abuse to fill out, much of which they won't have access to. This can be very intimidating and perhaps deter them from making any report whatsoever. It's based upon two mutually exclusive concepts. First, the respondent is a violent person who is guilty of domestic abuse, and the respondent is also at the same time a law-abiding citizen who will obey the order. This bill will create a false sense of security, which will actually endanger the petitioner. As has been noted, the filing of such an action will in fact escalate the violence in many cases. This will create many, many problems for law enforcement. They're expected to take possession of firearms, the description of which they don't know. They don't know the make, the model, the serial number, so they're really not sure what they're looking for, and they don't know when they've succeeded. The bill allows for search warrants to be issued. However, when searching beyond the respondent's home and vehicle, should the courts decide that the firearms may be elsewhere, search warrants could possibly be issued for other residences. This could result in the firearms owned by the resident of that house having their firearms confiscated because law enforcement could not tell the difference between those belonging to the homeowner and those belonging to the respondent. Provisions of this bill are a constitutional minefield, and it'll create legal entanglements for local law enforcement, none of which are included in the fiscal note. We ask for an unfavorable report. Thank you so much.
Thank you, and thank you for the congratulations, Mr. Jocelyn. Are there any questions, House members? Seeing none, that concludes the testimony for House Bill 83. We're going to move now to House Bill 48 with Delegate Tolles. I just saw her. Along with Delegate Tolles, I'm going to call up Elizabeth Van Horn. Come on, yep, come on up. Elizabeth Van Horn. Kenneth Wardlaw, or Wardlaw, I'm sorry.
How are you?
Alexa Richardson. Maria Valamar.
Yeah, absolutely.
Angel Cook.
How you doing?
Ms. Cook, are you here?
Yes, good.
Okay, it looks like everyone is here. Delegate Tolles, whenever you're ready, you may begin.
Thank you so much.
And welcome back.
Thank you. First time back. Thank you so much, Chair Bartlett. Again, congratulations to you. Vice Chair Davis, congratulations. Welcome to all of my former colleagues on the welcome to the new colleagues on the Judiciary. I'm happy to see my old colleagues here. And so many of you have heard this before, the TPR bill. I want to thank you for the support and questions over the years. So I'll just get right into it. We know that when a child comes into the foster care, the Department of Social Services should make an effort to reunite their child with their parent. And these are called reasonable efforts. Examples of reasonable efforts include scheduling visits between the parent and child and siblings, referring the family to counseling, assisting the parents find drug treatment options, or enrolling the parents in parental classes. At every hearing, the court makes a determination of whether the DSS has made reasonable efforts toward reunifying the family. Reunification is always the default plan unless the court changes the permanency plan to something else like adoption. Many statutes says essentially that once a child has been in foster care for around 15 months, Department of Social Services can ask the courts to change their child's permanency plan to adoption. And DSS can file a petition to terminate the parental rights. If a parent disagrees with the plan of adoption, they have the right to object to the TPR petition and have a trial, while the court has to decide whether terminating parental rights is the child's best interest. Parents may choose to consent for a number of reasons. They may feel like they're making progress and they can parent their child. They may feel like DSS did not do anything to help them in reunifying them with their child, and they want more services. They are not able to get a satisfactory agreement that would allow them to have their child adopted. There are many reasons, and you've heard this before. The problem with the law is that, for many reasons, one places a parent in a position of having to choose between which child. Do they fight for one expense over the other child? And so you will hear from the panelists here what some of the other reasons are. I don't want to go over my time. And so it is both unfair to the parents to have to make this choice, and waiving the reasonable efforts hurts not only the parents but the children as much. And so I ask for your support for HB 48 in an effort to allow the parents to reunify with their children and or do not take their other children away from them. With that, I yield back my 5 seconds.
Thank you. Excellent. Do you have a preference on who goes next, Delegate Toles?
Ken Warlock.
All right, Mr. Wardlaw.
Thank you, Madam Chair.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Kenneth Wardlaw. I'm a supervising attorney with the Parental Defense Division of the Maryland Office of the Public Defender. I'm testifying today to urge you to issue a favorable report for House Bill 48, the Right to Fight Bill. House Bill 48 would get rid of the provisions of the Senate and family law statutes that say that the Department of Social Services, or DSS, does not have to make reasonable efforts to keep a parent and their child together if in the past a parent fought to keep their parental rights to another child and lost that fight. When there is a termination of parental rights case, the current law makes a parent choose between fighting for this child and getting services for other future children to reunify. If you contest the TPR and make DSS prove that your parental rights should be terminated forever, you lose the right to have DSS provide you with reasonable assistance from the DSS to get your subsequent children in the system returned to you. If you want DSS to give you reasonable assistance, you must agree to give up your constitutional right to your child and agree to terminate your parental rights. Having to ever make this difficult decision puts the parent into an impossible choice in this regard. No parent should have to make this choice. If I've been forced to pose this impossible choice to a 17-year-old client who herself was in foster care with DSS. She had a child and DSS took her child from her. When DSS filed a petition to terminate her parental rights, she chose to exercise her constitutional right to fight the TPR, and she lost. Now, if she ever had a child come into care in the child welfare system, she would not get the assistance from DSS. It is for these reasons that I urge you to issue a favorable report for House Bill 48. Thank you.
Thank you.
Thank you. Madam Chair, Madam Vice Chair, and members of the committee. My name is Nina Villamar, and I lead the Parental Defense Division of the Maryland Office of the Public Defender. Our office represents about 95% of the parents in Maryland's child welfare system, including parents who are facing termination of parental rights, meaning the permanent lifelong loss of their relationship with their child, so that a child may be adopted or remain in foster care until adulthood. Over the past 2 years, we have advised roughly 60 parents that if they fight a termination of parental rights and lose, the Department of Social Services may no longer be required to provide basic reunification services meant to help families safely reunite with their children now or in the future, and that penalty can last for the rest of their lives. I want to explain today how the law currently plays out in real terms and why House Bill 48 matters. Imagine two parents who lose a baby to foster care. Both parents struggle with substance abuse, housing instability, and unemployment. After 15 years, DSS seeks to terminate both parents' rights. The father disengages, he stops visiting, but he consents to termination. The mother does the opposite. She visits consistently, she enters treatment, and she fights to get her baby back. She goes to trial and she loses. Her parental rights are terminated involuntarily. That single decision follows her forever. 2 years later, that parent is sober, employed, and stable. She has another child, but during a temporary crisis, that child briefly enters foster care. Under current law, DSS can ask the court to deny her reunification services. Services like helping her find housing or getting a treatment referral or arranging for visits with her child. Not because she's dangerous, not because she abused the child, but because she fought for her child, her first child, years ago. The judge in this situation has no discretion. Not only does the mother lose out, but the child loses out too on the chance to being reunified with the parent who wants her. For these reasons, we respectfully request a favorable report.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the Judiciary Committee. Thank you for the opportunity to testify today. My name is Elizabeth Van Horn, and I'm a clinical social worker here in support of House Bill 48, the Right to Fight Act. While I'm a part of the Parental Defense Division at Maryland's Office of the Public Defender, I am offering testimony in my personal capacity.
Excuse me, Ms. Van Horn, can you move the mic just a little closer to you?
Sure. Sorry,
Thank
should I
you.
start over? Can you hear me better?
No.
Okay,
Thank you.
During my nearly 15-year-long career, I've witnessed firsthand families try to recover from rather impossible circumstances, all of which are difficult to grapple with and require assistance to remedy and sustain. Often parents are forced to decide between fighting for their now or their future when faced with the termination of parental rights proceeding. This is an ultimatum like no other. It causes irreparable psychological harm to the family. A parent's innate instincts are to fight for and protect their children, yet the law asks parents to abandon their fight for their current children for the sake of potential future parenthood. This fractures family connections and dissolves trust. It leaves children feeling as though their parents simply did not fight for them or try hard enough to reunify. Children then grow up in a system without a legal parent, thinking that they were not wanted or worth the fight. Parents who find themselves bound up in termination of parental rights proceedings don't wind up here by happenstance. The deep and ever-growing roots of intergenerational poverty and the ripple effects of trauma reach far and wide, leaving parents with pervasive challenges that require resource and guidance. For them, support is necessary, not negotiable. The reality is that recovery and breaking these cycles takes time that is often not afforded to parents navigating termination of parental rights proceedings. This not only severs family connections, but it also denies parents an opportunity, the chance to overcome life obstacles with support from social services should they ever fall on hard times again. Parents should not have to fight, or should have the right to fight and a right to supported recovery. Families never stop needing assistance, theirs, yours, and mine alike. House Bill 48 affords a fair shake at recovery and the opportunity to parent, one of redemption, not sacrifice. I ask that you too support parents via House Bill 48 and issue a favorable report.
Thank you.
I respectfully urge a favorable report on House Bill 48. For Maryland House Judiciary Committee, the Right to Fight Act. I am favorable. My name is Angel Cook. Good afternoon, chairmen, women, members of the committee. My name is Angel Cook, and I'm here in strong support of HB 48. Yesterday, my son, Mighty, turned 23. His birthday. In 2006, the state used shortcuts. This bill, which seeks to fix until my bond with him was over. I lost him in 2006. Mighty, because he still lets me call him Mighty, despite they changed his name to Aubrey. He still lets me call that and all of the family because he says it makes him feel loved. He doesn't recognize the name because he doesn't get love behind that name. We found each other years ago, despite him being adopted, through a private agreement. We have been extorted from the family, the adoptive family. We have been extorted for the whole time. My mother passed, and that money I wasn't able to provide any longer. The neglect has still went on till today. Through that private agreement, I have exhausted my savings. I can't afford another attorney for my other child, who was also taken at a separate time. Because of the state shortcuts, I was robbed of the basics. I'll never be able to tuck my children in since they were taken. I never got to take them to the first day of kindergarten. I haven't been able to play Tooth Fairy, something I always dreamed of. Those moments that the state stole from us, I can never get back. In 2020, I lost my daughter, Destiny. She was born 8 days before my mom had passed. I was drowning in grief, going through a family dispute that left me isolated and only with my savings, because that siblings took my inheritance because I had went to jail. Because I have ever had a record, I never had a record before, but begging social services for the services for my medically fragile child, and instead of the support, they took him from the hospital. They gave me $18 for my daughter that weighed 18 pounds. I didn't start going to the jail until the system crushed me. And the recovery, my grief, and the struggles that I was going through did not fit into that 15-month box. It has been 6 years since I've seen Destiny. They have cut the visits off for my son and her as siblings because they say they're her parents. They're parents. I urge you to pass this bill and make it retroactive so families already broken can have justice. I'm also an advocate for this issue and other issues that I've faced throughout this whole time. And I respect for you to urge favorably for a House Bill 48 so that we can have a reasonable chance and we don't have to wait until they're 18. They shouldn't have to. But I would like to tell more of my story. I only have 2 minutes. So at a further time, I could share more, but this is bad policy that has been upheld for 14 years that I've been fighting. And because I lost my first son, my first child, Destiny was already taken by the time I got sentenced for survival theft of Pampers and diapers and things that I needed, because I just needed a house. After my family took me out of my inheritance, I just can't afford to fight.
Thank you, Ms. Cook, and I appreciate you coming down and sharing your story.
Thank you.
Ms. Richardson?
Thank you. Thank you, Angel. Good afternoon, Madam Chair, Vice Chair, and members of the committee. My name is Alexa Richardson, and I'm an attorney at Civil Rights Corps, a national civil rights organization that focuses on ending injustice and enforcing the constitutional rights of poor communities. I urge a favorable report on HB 48. Maryland's current policy of punishing parents for contesting the termination of their parental rights, it's bad policy, and it contravenes well-established constitutional principles around the right to family integrity. It endangers a parent's due process right to fight to keep their parent, something many loving parents would want to do. If a parent chooses to fight and then loses, they're denied the family integrity due process rights that protect their relationships with future children they might have. The rights to family integrity held by their future children, because those children too have a right to be with their parent and with their family, are also endangered when the state no longer has to make efforts to keep that family together. In addition, as child welfare law expert Vivek Sankaran has written, in the criminal legal system, we recognize that prior convictions do not make someone permanently guilty of future bad acts. In any case, the burden lies on the state to show that interfering with a fundamental right, like the right to family integrity, is justified and necessary for each child. This principle applies to parenting. If a parent's gone through, for example, treatment and recovery, and a prior struggle with addiction should not be used to permanently label them as unfit to parent. And that's exactly what the current law does. I want to address one way that families come into repeated contact with Maryland's child welfare system. Maryland is one of a small minority of states that has a birth match policy, where when a parent with a prior TPR gives birth, they're automatically, the state is automatically alerted, and that can lead to removal of that child and immediate adoption out. And so for those reasons, I really urge this committee for a favorable report. Thank you.
Thank you. Thank you, panel members. We have one question so far from Delegate Woods. Delegate Woods.
Thank you, Madam Chair. I would like to, my question is this. I'm hearing a lot about the impact of addiction. And the one thing that we do know about addiction is that, and I'm sorry, I just lost my word. Help me. When a person goes relapse. Thank you. Couldn't get the word out. That relapse is actually considered a part of recovery. And so I'd like to know how it is, because I'm well aware of the statute, the 15-month statute, and a lot of times people's addiction has well exceeded 15 months, right? So how we expect for them to clean up their act in the process of both addiction and reunification efforts. How do you all think we can better address the fact that we acknowledge that relapse is a part of recovery? And if I can just ask a quick second question, if I can put it out at the same time. The second question is, never mind, go ahead with if you can just address the first question. Thank you. Whoever can address the question, please.
The problem with how addiction is currently addressed is a serious one. You're absolutely correct that the current timelines in Maryland's law do not comport with what we know about substance use disorder and how long it takes sometimes to overcome that. We have parents who do often relapse, and we know it's part of recovery, and yet after 15 months, the law requires that the Department of Social Services file a petition to terminate parental rights. And so when a court is deciding whether to permanently end the parent-child relationship, they're looking at a snapshot in time. Unfortunately, the way the current law is worded, that snapshot in time is permanent, and it follows the parent no matter how much time has passed. I have literally represented a parent whose parental rights were terminated in 1 year. She had another child 20 years later, and that involuntary TPR was still a stain on her record, and it gave the department the basis for asking the court to waive reasonable efforts. So if substance use was not her issue 20 years later, but she had other issues, and the department was not required to provide her with assistance for seeking mental health treatment and housing.
And now may I ask the other question? Yes. Thank you. So my next question is, we talk about the termination of parental rights, but I don't understand, and if somebody can help me to understand, that we don't address the impact of the termination of parental rights as it relates to the children, because it's not just the termination of parental rights. Sometimes people have the capacity to terminate siblings. And I'm speaking as a person who was in foster care for 12 years before being adopted. And the fact that you can actually legally lose all contact with your siblings. Could you address that too, please?
Yes, Delegate, and I really appreciate that question because you're correct that it is so overlooked. People don't consider the impact on the child. When parental rights are terminated, the relationship between the parent and the child is forever severed. That also means that the child's relationship with siblings and extended family like grandparents, aunts and uncles and cousins that also is terminated. When the child, if the child is adopted, that child, the adoptive parents have total control over who that child has contact with. So even if that child wants to have contact with the sibling, a brother or a sister that they know about and that they have a relationship with, the law does not require that relationship be allowed to continue. And I should add that just because parental rights are terminated does not mean that the child is adopted. There are children who end up staying in foster care until they age out of the system. So parental rights can be terminated even if there are no parents waiting in the wing. So if no adoptive parents are waiting in the wing. And that's one of the reasons that parents object to the termination of their parental rights. They don't want their child to languish in foster care. There's actually a website where they show pictures of children who are ready to be adopted. And it's a heartbreaking website to look at because it makes me think of the websites that exist for dogs that are waiting to be adopted by people. It's the same type of website. And these are children who may end up never being adopted, but yet they have parents who, even though they wanted to remain in a relationship with them, were not permitted to by law. So that's one of the many reasons why parents object to the termination of their parental rights. They may object, and if a court hears the case and thinks that parental rights should be terminated, that decision is held against the parent going into the future. I hope I answered your question.
You did, thank you. Thank you, Madam Chair.
Delegate Conaway?
Thank you, Chair. Thank you, Delegate, for bringing the bill in panel. Can you tell me where's this relapse as part of recovery? Where is that? Is that medically acknowledged, or where is that?
So I'm Elizabeth Van Horn. I'm a clinical social worker, and it is a part of social work and the premise of social work, but also an addiction treatment. And I do think it started to be adopted as a part of court language, but it is a clinical sort of well-known fact that relapse is a part of the process.
It's a clinical well-known fact. I'm looking at it on the computer and it says people say relapse is part of recovery, so that if someone relapses, that they will still be welcomed back. I'm asking you, do the doctors say that the relapse is part of your recovery, or is this something that is just pretty much said as an understanding of your fellow humans, I guess?
Yes, I would say in counseling someone around their substance use, it is a conversation that you have with someone in active use and it's still in recovery. So recovery is a lifelong process, and that is a discussion that you should always be having as a clinician with the people you're treating.
Thank you.
I'm going to just go on down this way, starting with Delegate McComas.
Thank you, Madam Chair. Are other states as fixated on 15 months like Maryland is?
I'll let the courts.
Just if you know, if you don't know, I don't expect you.
Yeah. Yes, Delegate, that is, the 15-month timeline is based on a federal statute that requires that the state move towards attaining permanency for the child. And 15 months is sort of an arbitrary number that was selected by the federal government. And so the states have followed along that same guideline.
Okay, so my next question is, if it's a federal mandate, will there be problems if we pass the bill to not have it 15 months? And that's number one. And number two, do we have to put another deadline in it, or we can just say, let it move on? And, however the mom and the father, the family, the extended family, and the parent and the child, they can work it out or they can not work it out. But in other words, provide some hope. But do we have to have another deadline?
So HB 48 does not change Maryland's timelines at all. It only says that if parental rights are terminated this year and next year you have another baby, the department can't ask the court to not provide you with reasonable efforts for that second baby. But they can still, this is not a bar to the state still complying with the 15-month rule. this bill does not change the timelines at all. They can still file to terminate parental rights within 15 months. It's just that between the time that they remove the child and the 15-month deadline comes, that they have to provide some reasonable efforts.
Okay, so in other words, the parent has to get their act together within that 15 months? Is that kind of what you're saying?
Yes, that's correct.
Okay, all right. So do you think that that's something that can be accomplished by, because you know your clients and you know kind of what they're dealing with. Do you think that that's workable?
We see a lot of success with many parents who are able to overcome the circumstances that led to their child being removed from them and placed in foster care to begin with. It's absolutely achievable. Oftentimes, the parents that we represent are impoverished. They don't have the resources to access the services, and that's why they need the assistance from the Department of Social Services, so that they can access the things that they need in order to put themselves in a situation where they can safely parent their child. And that's what we're asking. That's what this bill seeks to address. Don't take away those services that the parents need in order to safely parent their child.
And just one extra question. So has there been any studies that this 15 months and the fact that there can't be any reunification, has that affected the children at all? And has there been any psychological studies? Because I mean, I can certainly understand it affects the parents, okay, because it's everybody has to live on hope, okay, all right. So my thought is how does that affect, is there studies that affect the kids that, you know, that door has closed and they have to go elsewhere, or they're a child of the state, which is pretty sad, or they're adopted out and maybe they don't get to know their family and know their siblings or their parents. So I just want to know, I would think it would be a psychological issue for these kids and kind of haunt them, but maybe not.
So I'll let them answer. I definitely want to keep to the spirit of the bill, the 15-month. I hear you, Delegate. It's not in the bill. Really, it's, as was indicated with the Office of the Public Defender, is trying to get not take away a subsequent child because you've had a mistake in the past. But I definitely hear you. I will let someone answer it. I definitely want to try to keep to the spirit of what's in here because the 15-month, obviously, it's not in here. And so I want to keep to that. But I definitely hear, and I will also say that, you know, I think there is hope. I think people can recover because it does depend on the situation. It could be something minor, and it could be something more serious. And that's why, you know, we leaving it up to the courts to make that decision. But at the end of the day, I do believe that there can be recovery for some individuals within that allotted timeline. But again, that particular piece is not in the law. But I believe that there is hope for individuals to turn their lives around if they make a mistake.
I will just address, and thank you, Delegate, for that question, because I think it's a really important point, which is that termination of parental rights, long-term family separation for children, even short-term family separation for children, we now have decades of data showing how harmful that is for children. When that primary attachment relationship is broken, children suffer a host of long-lasting, devastating consequences from, you know, long-term health complications, higher rates of juvenile and adult criminal encounters, higher rates of suicide, early death, educational outcomes across the board. And so what this bill does is it just asks the state, again, to make those same reasonable efforts for a parent that may have struggled in the past, may have lost parental rights in the past, that they would for any other parent, to provide them with the services that could bring that family back together and hopefully reduce the trauma that those individuals experience.
Okay, thank you. Delegate Simmons.
Thank you, Madam Chair, and thank you all for bringing the legislation forward. So when we look at some of the positive outcomes of advocacy that the Office of the Public Defender is doing, juvenile services, can you talk a little bit about the fact that when you come to parental rights and what is being lost there, do you see any trends when it comes to whether or not you have a high number of minorities that this is taking place, certain county that y'all see that is taking place? And what more can we do in addition to what we're talking about here to continue to support the efforts?
There are high rates of racial disproportionality in Maryland's child welfare system. And my data is a little out of date. I think it's 2022 data that I know of, that Maryland actually ranked 6th in the nation for the rate of disproportionality of Black children being removed from their homes instead of white children. And so a very poor rate nationally. And so I think there are a lot of ways that we should be rethinking how we're approaching families. Bias can enter the system at every single stage of the process. So, you know, when that birth match call gets called in on two women, you know, coming from different circumstances, coming from different racial backgrounds, how are they being treated from the moment they encounter that system? What opportunities and chances are they being given? What support to reunify are they being given? You know, it just permeates the system as we have it. So I appreciate that question. I think changes like this are ways that we can start to turn those cycles around and really support the families in Maryland instead of coming from a punitive perspective.
Thank you.
Okay, the Vice Chair.
Thank you, Madam Chair. I am interested in where this current policy derived from. It seems pretty illogical to throw someone out that you know needs help. Do you know where this policy came from?
OPD.
I actually can't speak to the source of this particular subsection of the statute, but I will direct you to the Courts and Judicial Proceedings article, which lists all of the bases for waiving reasonable efforts from the state. And the involuntary TPR is lumped into a group of exceptions to reasonable efforts, things like severe torture of a child, murder of a child, abandonment of the child. And then involuntary TPR was just thrown in there. It's illogical, and it doesn't serve a child in any way.
Thank you.
Delegate Erican.
There we go. Thank you, Madam Chair. I just want to bring this into land with a hypothetical. Maybe you guys can help me think this through. So I was thinking about Ms. Angel's case that she was talking about. So let's say we have a situation where there's a mother and the father, and the father does not fight for that first child. The mother does fight. They both have, separate of each other, a child 20 years later. The father has the ability to get services, the one who willingly abandoned the first child. But the woman who fought hard for that child and may have still lost it does not have that same right.
That's absolutely correct, Delegate.
Okay.
And that was the one sentence that I forgot to read for my testimony because my time ran out.
I psychically was connected with you, but I was thinking like, oh my gosh,
Yeah.
so someone who literally had bailed on the first kid, had another kid, could get these services, and the woman who fought hard because she wanted to keep that baby and lost it anyways has nothing for the next child.
That's absolutely correct,
Okay.
and we see that very often.
That's really sad. Thank you.
Okay, thank you all for your testimony. Thank you, members of the committee. That concludes this particular panel for House Bill 48. We're going to move on to our favorable with amendment panel, and they are both online. We have Katarina Jones and Richard Perry. Oh, who's that?
Madam Chair, Ms. Jones is here in person.
Are you Ms. Trivedi?
No, I'm Katrina Jones.
You're Katrina, oh, you're here instead of online, I got you.
Yes.
Okay, is Ms. Shanta Trivedi?
Yes.
Oh, she's virtual. Okay, we have one person who's testifying favorable, and then we'll move to you. Just a second, Ms. Jones. Okay, Ms. Trivedi, whenever you're ready, you have 2 minutes. Thank you.
Thank you. Good afternoon, everyone. I'm sorry I couldn't be there in person due to snow. My name is Shanta Trivedi, and I am the faculty director of the Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore School of Law. And I teach and I write about the child welfare system, and I've also represented hundreds of parents who have been separated from their children, many of whom experience termination of parental rights, or TPR. HB 48 would ensure that more children and their families get the services that they need to stay together. And as discussed, if the state wants to remove a child, they must make these reasonable efforts, but there are a few conditions known as aggravated circumstances under which these efforts are no longer required, and HB 48 would eliminate one of these if the parent had previously had the rights to the child terminated. And to answer the question of where this aggravated circumstance came from, it is from a federal law called the Adoption and Safe Families Act. Reasonable efforts are part of our law because our child welfare system operates on a basic premise that children do best when they're with their families, and that even when parents have made mistakes or come upon hard times, with support, they can parent safely and reduce the harms of separation both to them and their children. In so many situations, parents are living completely different lives than they were when their rights to their previous child were terminated. I had a 16-year-old client who was in the foster system herself. Her 2 small children were removed because her boyfriend was abusive, and she struggled with managing them on her own. Given her age and maturity, she was unable to comply with the requirements she needed to reunify her with her children, and her rights were terminated. A few years later, she's in her 20s, finished school, new healthy relationship, but still struggling with poverty and the effects of trauma. She has a new baby and CPS intervenes. She could not get any of the benefits of any services that could help her and her kids, based solely on this past termination when she was a child. It is important to note that TPR is not reserved for the worst cases. One of the seminal Maryland cases on this topic is about a mother with a cognitive disability whose rights were terminated because she could not get housing or a job within an arbitrary legal time frame. She lost her rights to her children forever because she was poor. The child welfare system is supposed to prioritize reunification because we know that this is generally what is in children's best interests. And I just want to note that we are watching ICE separate families in our communities in horror, but we are separating families every day in our family courts, and we need to give families what they need to thrive. Thanks so much.
Thank you. Are there any questions for this last witness who is on the favorable panel? Okay, we're going to move now to the favorable with amendment panel, and that would be Ms. Katrina Jones, who we already have, and Mr. Richard Perry, who is online. And Ms. Jones, whenever you're ready, you may begin.
Okay. Hello. My name is Katrina L. Jones. I am an executive director of Dreams R Us Incorporated, a nonprofit grassroots organization helping families rebuild through trauma. I am, with support of HB 48, I am here as a mother as well with an active Senate case and as someone who has supported families across the state of Maryland and other states going through these issues. I'm asking to support House Bill 48 because Maryland's current policy allows DSS to deny reunification services based solely on a parent's past, even when that parent has healed, stabilized, and done the work to rebuild their life. There is no assessment of who they are today, no recognition of rehabilitation, and no real chance to reunify. We know from decades of research that foster care does not erase trauma, it often reproduces it. Children can spend up to 18 years in state custody, an entire childhood, while their families receive little to no support. And the outcomes are clear: higher rates of homelessness, incarceration, mental health crisis, and intergenerational system involvement. The fiscal reality is just as clear. It costs Maryland far more to keep a child in foster care than to support a family through reunification. Foster parents receive stipends, tax benefits, child care vouchers, and resources. Biological families in crisis are routinely denied. Supporting families is not only humane, it is fiscally responsible. And we must name the imbalance. Parents faces the harshest consequences for every mistake, even old ones. But when caseworkers, judges, or attorneys make mistakes, they are protected by broad immunity. Families pay the price, not the system. HB 48 is one step towards balancing the scales. This bill does not guarantee reunification. It guarantees fairness. It ensures that parents are evaluated based on their current capacity, not their past trauma, and it gives children a real chance to stay connected to their families whenever they're safe and possible. Maryland cannot keep funding separation while starving families of support. It's time to free the bag and free our families. Thank you, everybody, for your time.
Thank you. Mr. Perry?
Thank you. Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Richard Perry. I supervise the Child in Need of Assistance Unit for Maryland Legal Aid's Prince George's County office. And I'm here to explain why Maryland Legal Aid has proposed an amendment to House Bill 48 and why that amendment is necessary to preserve judicial discretion and ensure that courts can treat each case and each child as unique. For background, this issue involves whether the involuntary termination of parental rights of a sibling means that the court can waive reasonable efforts to reunify a child with the parents in a subsequent separate case of a sibling. The portion of the law at issue today only applies to a narrow set of circumstances when a parent's rights of one child have already been involuntarily terminated and a second sibling child is now before the court in a civil or TPR matter. Under current law, the department may ask the court to waive reunification efforts for the second sibling child. This authority is used very rarely, but when it is used to protect siblings from the same serious demonstrated harm present in the earlier case. Before TPR can occur, remember that the first child must have been found to be a child in need of assistance. The court must have determined that there was abuse and neglect, and that the issues were not resolved for many, many months. And then the department can file for a TPR. The rules of evidence strictly apply at a TPR. The court is required at a TPR to consider the impacts of that TPR on the child and on the child's attachments and bonds. Right now, there is no discretion for the court to not waive the reunification, the reasonable efforts towards reunification. There should be discretion both ways. As currently written, the bill takes away the discretion of the court. The court should be able to consider each child individually and the circumstances of each individual child. And that is why we urge the court to adopt the amendment.
Thank you. Seeing no questions for this panel, this excuses this panel for favorable with amendment. We're going to now go to our panel for unfavorable testimony, unfavorable. And I see one person, that is Judith Chagrin. Quick question. Is Erica Lamont in the room? Okay, Mr. Graham, whenever you're ready.
All right. Chair, Vice Chair, and members of the committee, my name is Judith Chagrin. I'm speaking on behalf of the Coalition to Protect Maryland's Children, and I am I'm a social worker with 35 years of experience delivering public child welfare services. I've served thousands of families and their children. We respectfully urge an unfavorable report on House Bill 48. House Bill 48 eliminates a very narrow but critical child protection tool to help children who are already in foster care move more quickly towards permanence. Under current law, reunification efforts may be waived by the court when a parent has involuntarily lost parental rights and a subsequent child has been similarly maltreated, adjudicated a child in need of assistance, and placed in state custody. This waiver exists to prevent children from lingering years in legal limbo and applies to a really limited set of children. The bill is framed as the Right to Fight Act, but no parent is denied the right to fight. That opportunity begins when the first child enters care, when parents receive extensive services, legal representation, and time to demonstrate change. Termination of parental rights is pursued only after all of those efforts failed and the court has approved the change in plan to adoption. When a parent has already lost parental rights involuntarily and a second child enters care under similar circumstances, history matters, not to punish parents, but to protect children. And I want to emphasize the voice of children, not their parents. For a child, delay isn't neutral. A year in the life of a 1-year-old is their entire life. What House Bill 48 does is shift the system away from timely permanence and towards delay for delay. Child welfare isn't about fighting. It's about whether children in state custody will be allowed to belong sooner rather than later. For these reasons, we urge an unfavorable report.
Thank you for your testimony. Delegate Erican.
Thank you, Madam Chair. Your testimony made me have another question. So even if this bill passes, it's still true, you can tell me if it is or not, that if later down the road another case has been brought against with a separate child, a judge, the evidence that a parent had lost a previous child could still be admitted into that second case. It just wouldn't be allowed to be sort of fast-tracked. Is that right? They could still tell the court she had lost a previous child, correct?
Yes.
Oh, okay. All right. I just want to make sure. Okay, thank you.
Delegate Congola.
I just wanted to know if you could provide some data showing the, you know what, I'm going to just say this, okay? In my experience, we've seen a lot of families suffer as a result of not receiving the proper services through social services, through agencies. There have been barriers to people actually completing the requirements to receive their children. And some of those barriers have been as a result of the system not providing the resources and services that these families were mandated to complete. And, you know, so in your experience, have you seen, you know, those instances of families kind of being penalized and not given the support that they need to reunify or preserve that family unit?
I would love to have a much longer discussion with you about how child welfare works and what actually happens. But I can tell you from my point of view, having been the administrator of the second largest foster care program in Maryland, that my social work staff pulled out all stops to support families and children. We have we have flexible funds that can pay and does pay for individual services that medical assistance doesn't pay for. We've talked a lot about substance use disorder. Absolutely, we as a state need to be doing better. 70% of the kids entering foster care in my county, young kids 0 to 5, were the result of endangering parenting behaviors that were associated with substance use disorder. And we know that relapse is part of recovery, which is why sometimes kids linger for years while a parent gets themselves together, relapses, nobody is rushing to terminate parental rights. We want to reunify children. This idea that public child welfare is out to get parents is simply not correct. And I wish I could have children here who could say, foster care saved my life. I wish I could show you the studies that show disparity isn't the result of bias, but about what happens to bias in child welfare, but what happens to children before they enter foster care. What happens in the communities they're living in before they enter foster care. So no, I believe that parents are afforded services, and I know for sure that there are flexible dollars to assist with individualized needs.
Okay, and I'm sorry, ma'am, one more question, please. And I appreciate the work that you've done, and I would probably say that I'd be more interested if you have any data to share with us in terms of your success rates, because it sounds like your program may be a unicorn compared to other programs in the state that provide services to families.
The question is, how do you define success through the eyes of the child.
Okay, well, ideally, that child will be, that family will be preserved, because we know that that's the number one protective factor for any child, is to be with a nurturing, loving parent. And our job as providers is to make sure that that family has the resources. And oftentimes, those resources are not available through many agencies, but it appears that your agency has different outcomes.
Keep in mind, I'm talking about children who have already entered the foster care system, that their family was not able to be preserved. I will tell you that Maryland is has one of the lowest placement rates in the entire country. We are number 2, second only to New Jersey. I think it's 1.2 children per 100,000. And that we have brought down the number of children in foster care by, I'm going to say half. It's now 3,000 something from a high of 10,000 something, maybe a decade or two ago. And I know I did some work in the city that they are successfully preserving families through their family preservation program without subsequent injury or abuse to the child. So a lot of work has been done to preserve families, which then means by the time they enter foster care, they have really serious and embedded issues and problems.
Excuse me, whoever's phone is constantly going off, can you please turn it off? Or I'll ask you to be excused, if you can't. Thank you.
I thought it was a musical background.
Did you finish your thought?
Oh, I did. That in fact, Maryland has done some very good work on prevention and has sharply reduced the number of kids entering while also able to keep them safe through family preservation programs.
Great. And did you finish your question?
Yeah, I did finish the question, but I just, wanted to say that it sounds like this bill ultimately is wanting to prevent parents to be, penalized for past behaviors. And, it's incumbent upon us, and I'm sure you would agree as a social worker, to make sure that those families are kept intact, because we know that if families are intact, we don't have to legislate a lot of the societal ills that we have to deal with crime, poverty, mental health, drugs, and alcohol. Would you agree with that?
Yes, but I would also point out that oh God, I lost my thought. That I want to be really clear that this waiver, I honestly cannot even remember in my 30 years when it was applied. It is such a small number of parents for whom it's relevant. They had to have involuntarily lost their parental rights, and a second child has to enter care, be found, a child in need of assistance. And our first goal is always reunification. It's not, oh, you lost your parental rights involuntarily? Well, we're going to do the same with this child. We are always going to assess that second child and the family's status at that time. So it's not an automatic. It's not, oh, they involuntarily lost parental rights, so therefore we are going to request a waiver and the court will grant it. I think the amendment I didn't quite catch would actually allow the court more discretion whether to grant that waiver or not, which I think could be a very good compromise.
Thank you, and thank you, Madam Chair.
Sure, thank you. Delegate Woods.
Thank you, Madam Chair. Thank you, Ms. Shagrin, for your testimony. As a person with lived experience, as I previously said, having been in foster care for 12 years and then who became a licensed social worker, I have to respectfully disagree with you with some of what you're presenting, and that is because one of the concerns that I have had is that there are many occasions when the foundation of what leads to what is diagnosed or determined to be neglect or abuse has more to do with the way that that parent was raised. I was born to a very young parent. She was a teenager. And I was removed at 6 weeks because she had a child a year before me who was removed. There is no real documentation that says that she was neglecting or abusing the child, okay? The concern was that she was a teen mother, which never really was, and I know this because I said to you as a licensed social worker, that we find out some of these teen mothers were forced. Would you agree? Forced into the relationship that led to the birth of their children. And there's no real documentation that says that that person was not able to be a responsible parent, but the fact that they were a child, quote unquote, and this is, and I'm not going to tell how old I am. Actually, I'm 20 years old, and
Me too.
and so, you know, my birth may have been a little different, circumstances a little different, but the reality is, in working with young people, when I was a line social worker, I had a lot of concerns about the foundation of that child's background that, as far as I'm concerned, was never really adequately dealt with as it related to their ability to raise a child. I would love for you to speak to that, if you would.
So, knowing that we are both people of well, I'm especially a person of a certain age, but one of the things that I've seen over the 35 years of my career has been real changes in the way we regard parents and their issues. I did adoption, mutual consent registry, finding biological parents for adults who've been adopted, and I read a lot of old child welfare records, and I participated in old child welfare. And I really believe that, obviously not perfect, but that some of those trends, like condemning a teenage parent because they were a teenager, gone by the wayside, that we don't treat them the same way we once did. I had a client who had a baby as a teenager, and that baby was removed because we thought, oh, teenagers can't parent. Now we have lots of placements for teenagers and their babies to stay together. We didn't have that when I started off my career. And the goal of those programs is to support teenage parents. I have seen, well, I don't love it when our girls get pregnant young. I have seen girls who truly that baby has been transformative for them and has set them on the path of serious adulthood. So, you know, we give up a foster care subsidy. We used to require the baby come into foster care. That changed, I'm going to say 15 years ago. We're allowed to give a subsidy to the foster parent without the child having to be in foster care when the teen mom is living with that foster parent. So I'd like to believe what happened to you would not happen today.
And I appreciate that, may I, Madam Chair? But again, in my work, and you said 15 years ago, that's not that long ago. It's been less than 15 years that I'm aware of young people who really, and I'm going to preface this with my belief and the fact that I believe that it is really dependent upon who's hearing the case. But it's been less than 15 years ago that I'm aware of young people who, as the social worker working for that child, was capable of taking care of their child and was not granted that opportunity.
Is there a question?
Is that true?
You brought up a point that
Thank you.
I would say not in my experience, but you also reminded me that children have attorneys, parents have attorneys, and judges make the ultimate decisions. And so it is more complex than a child welfare caseworker. Most of them are not social workers, making that decision independently and on their own. They can request the court to waive reunification efforts. It doesn't mean that the court is going to grant them. So children, even when they are the mother of a baby, if they're in foster care, they'll have an attorney for themselves as a child and also for themselves as a parent. And I think the public defenders who represent parents do a really good job.
Thank you, Madam Chair. Thank you, Ms. Shagrin.
Delegate Simpson.
Yes. Thank you for coming in. Thank you for your work. I'm wondering if you are aware that the actual Department of Social Services, Department of Human Services, actually supports this bill. Some of the things that you talked about, you know, historically, how things have changed because we've realized, as someone who was a Child Protective Services worker, I believe that Delegate Woods and I are both very aware of the process and how it works, and that this bill intends to fix some of those things, like you had said historically. Are you aware that the department supports this bill?
I'm not. I don't always agree with the department.
Okay. And so are you willing to give it a chance to see how it works? Since, like you mentioned, all those other things that you had said to Delegate Woods about things that had changed, that you would hope that what happened to her, which is exactly what this bill is intending to fix, Are you willing to give it a chance to see how it works?
I would like to study the amendments that were proposed to know whether that would in fact satisfy all parties. Again, it is such a small number of children that you may be right. It's not going to affect anybody, a child, one way or another. But once we remove it, it's really hard to get it back. So I would like to study Mr. Perry's proposed amendments.
My experience is it is not as small of a number as we would like.
Who have been involuntarily terminated and the
I
department?
think that it depends. I hear what you're saying, and I understand as far as where your organization may be, but that's not, there are 24 jurisdictions within Maryland, and they may operate differently, and so therefore some places may be greater than others. And this is one of those bills that I believe that the delegate is bringing forth to fix, to give, children a better chance. Are you willing to watch how that takes place on all the other things that you said we had done as a body? Are you willing to see how, as you said, they're still going to have a chance. It doesn't mean that there is no longer termination of parental rights. Right. That's not what this bill does.
It would mean the child has to wait. And what I would love to see is DHS's data about how many involuntary terminations there are and how many waivers have been requested and granted. That would help to inform, I think, all of our decisions.
Okay.
Okay, thank you.
Thank you. That concludes our testimony for House Bill 48. We're going to move now to Delegate Griffith and House Bill 12.
All right, back mode, stomping grounds.
It looks like nobody made it in but you, Delegate Griffith, from the snow.
Let's go.
All right.
I'm ready for it.
Let's go. If you're ready, we're ready. Thank you.
Yes, ma'am. Congratulations, by the way, Chair Bartlett and Vice Chair Davis. And esteemed members of the committee, today I request a favorable report on HB 12, Juvenile Sex Offender Registry, Qualifying Offenses, and Access. What this bill does is strikes right at the heart of student safety, victims' rights, and not just protecting the interests of the victims, but also of those who have been convicted of committing sexual crimes by not putting them back in harmful situations once again. What is the problem we're trying to solve? So right now I can tell you there is a high school student in the state of Maryland who was convicted of production and distribution of child pornography. Of course, their two young toddler siblings performed sex acts on each other. The student was convicted of it and then placed right back into a high school with a daycare program because the school did not know, and production and distribution of child pornography is not a reportable offense. I have another bill coming up to try to address that as well. So unfortunately, we're putting a child, a student, a juvenile, who did something terrible and has a propensity to do something terrible like this, right back in the very place where they potentially could do it again or be tempted to do it again. That's not in the toddler's best interest. It's not in the student's best interest. It's not in the school's best interest. It's not in our state's best interest. It's not and it's not in the victim's interest either. Schools right now, superintendents, principals are putting students who committed sex crimes against other students in classrooms with their victims because there are, as you can see in the bill and we'll talk about, there's a lot of sex crimes that are not reportable and not on the Juvenile Sex Offender Registry. So we're harming victims. We're opening them up to additional trauma and tragedy, additional PTSD. And then we're putting the people who've committed these crimes, again, in harm's way by putting them back in classrooms with the very victims that they traumatized. I've read some of the opposition testimony. I want to talk a little bit about that. As somebody who's the father of a severely autistic special needs child who's in the STRIVE program in Hartford County, I will tell you, this does not discriminate against the disabilities community. at all. Not only that, but I want to talk about exactly what the bill doesn't do. This bill does not prescribe what actions a superintendent shall take. It does not at all. A superintendent may make a decision to move the person who committed the crime out of a different classroom with the victim. It could be as simple as that. It could be remote learning. It could be a variety of solutions that do not include removing a student from the classroom. And even then, there's still a variety of mechanisms to make sure children get their constitutionally protected education here in the state of Maryland. Moreover, we are trying to add certain sex crimes to the juvenile sexual offender registry to include third-degree sexual offenses, fourth-degree sexual offenses. First-degree attempted rape is not on the list. Second-degree attempted rape is not on the list, and several others. So all we're trying to do is the right thing by students and victims, and also making sure we don't put people who've committed crimes back in harm's way. With that, I request a favorable report.
Thank you, and welcome back to Judiciary. I don't know if everybody knows that Delegate Griffith is a former Judiciary member. Delegate Woods, do you have a question?
Delegate Griffith, thank you so much for your testimony.
Yes, ma'am.
My question to you is, I'm very concerned about the fourth degree sexual offense, which can be something as simple as a 10-year-old slapping someone on the behind and then no longer being permitted in the classroom, literally till 18 years of age. Can you please explain why? And the second part of that is that many of these children, you spoke of the autistic child. We do know that children with pervasive mental health challenges and or disability challenges are known to be highly sexualized without technically even knowing what that is. Can you please answer how we can avoid this type of punitive behavior for children who may not have any concept of what they're doing? And something as simple as a child that hits a child on the behind at 10 and then can never go back to school.
Well, first and foremost, that's why we have the judicial process in place, where our judiciary can make educated, intelligent determinations on this is a 10-year-old doing something dumb and childish, or is this an older child doing something harmful and looking to victimize and impose power over another student, right? So that's the judiciary, and our legal process is in place as that guardrail. Additionally, factors like differently minded individuals, like those with autism, those things are also factored in as well, right? Like you see my son, 9 years old in the Strive program, who's nonverbal, who mans once in a while and just wants to eat all day. He walks up and touches a woman inappropriately. Anybody with common sense and good judgment is going to understand that he does not understand what he's doing, right? So a part of it is common sense and good judgment. Now, with that being said, and I do understand your concerns, I'm happy to amend some of these things and work on broadening this. I'm not going to die on the hill of this entire bill, right? But what we're trying to do, but there are certain things, attempted rape, right? You know, attempted rape isn't a smack on the butt, right? First degree attempted rape. So I think there's some things we can try to at least work to incorporate and move the ball forward. And then also giving the schools access to, and if I may, just a little bit, all the other thing, the other portion this bill does, it gives the superintendent and one designee access to the juvenile sexual offender registry. So it's very narrow. And we did that very deliberately because we don't want these children stigmatized in the school. And there's no reason that if a superintendent and their head of security for the whole school system knows about it and be able to make a decision within those two individuals, there's no reason anybody else needs to know about it, right? Children are moved from and out of and moved classrooms all the time for HIPAA things, and nobody at school level is allowed to know for HIPAA reasons. We're trying to create the same type of parity with this for, again, not only for the victims, but we don't want to put a kid back in a situation where they may reoffend.
Madam Chair, may I? Thank you so much. Thank you for that information. I do have a question, thank you, regarding the identified individual. We have the statute in place for the superintendent. I'm a little concerned about how we can assure that the identified individual, because there is no basis given, as I have seen in your legislation, that specifically identifies who that individual is.
So the way we wrote the bill was based upon Harford County's system. So Harford County is superintendent, and they have a countywide, school system-wide head of security. So in Harford County's example, that would be the designee, right? Now, does every school system have a head of security or another person?
Correct.
That's why it would be one individual in the head office that would be a co-collaborator to help make an informed decision. And maybe in some school systems, there'll be somebody dealing with psychology or looking at from another point of view, right? We don't want to be prescriptive. We're just trying to give the superintendents the tools to make sure they're not putting students who've offended in classrooms with victims or potential victims.
Thank you. I welcome the talk about some of those amendments. And also, I do think that we need to be more descriptive about who can be identified, because certain school systems and certain counties have different level of services and availability. And so I think it's extremely important that we know or define in some way how that superintendent can designate someone else.
I don't disagree, and I'm wide open to any suggestions.
Thank you. Thank you, Madam Chair.
Yes, Delegate Conaway.
Chair, thank you, Delegate, for coming in and presenting your bill. I was wondering, at what age/grade are the children/students taught the standard of what is inappropriate behavior or what you call touching?
I mean, I can only go off what is listed in the law for this, the sex offender, sexual offenses for third and fourth degree.
No, I don't think you heard my question.
Okay.
I said, at what age or grade are the children or students taught what is inappropriate behavior or touching?
I don't know.
Do you teach them in the third grade? Are they taught in the seventh grade? What grade?
I don't know. I mean,
Excuse me?
no, I don't know.
Thank you very much, Delegate.
Okay, Delegate McComas.
Thank you, Madam Chair. I just, I like your bill, okay? I just think that, you remember Kayla Hamilton, who was?
Correct.
Okay. And they did not charge the individual, okay, until they got the DNA back. And
That's a different situation. This is a situation where they have been convicted.
Okay, but my concern is that individual was in the Edgewood School. The other thing is he went down for a dental appointment, an hour one way with the social worker and an hour back with the social worker who was all by herself. What?
Can you move your mic down?
Oh, I'm sorry.
Okay.
Anyway, my bottom line is that I think that was a very serious situation. It was very clear that the guy murdered her she was on her phone to her boyfriend. And I guess what my concern is here you had a person who had also killed 4 people over in El Salvador, but that's a different story. That came out later. But the point is that this person was dangerous, obviously. And he picked on this highly functioning autistic girl and killed her. And it was a very brutal rape. And I guess what I'm kind of concerned, and that was a sex offense, okay? And I guess my concern is yeah, he wasn't convicted, but the point is he was eventually convicted and put kids and the social worker and the Edgewood High School students in danger. And I'm wondering, would you be willing that we could somehow expand it? Because the schools, he should have been in school virtually.
So I offered a bill
not what
last year.
happened.
I offered a bill last year, and another bill that I'll be presenting to this committee this year that I've already dropped, that deals with notifications for individuals suspected of committing violent felonies, which addresses that issue. So that's a different bill altogether, but I already have that bill ready to present to the committee. This one deals with just simply. Yep, we're already tackling it. This one simply deals with notification to the superintendent or designee of an individual who's been convicted of committing a sex crime, and then adding a few sex crimes to sexual offender registry.
So the other one will also
Mike.
be notification as well as maybe going forward.
No, I mean, well, that's a different bill entirely. My bill is not prescriptive as the action that should be taken by the superintendent. It is just a notification bill when it comes to informing the school.
Thank you. So how does this square with the confidentiality of children's records as far as their arrest records or their police records?
Well, again, that goes back to why we have such a narrow scope of who can be notified. Because, I mean, that's the rub, right? Like if, my daughter is in the classroom with someone who's attempted first-degree rape, whose rights outweigh the others? The student who's potentially victimized or the student who's been convicted of committing an attempted first-degree rape, right?
But that's not my question, actually. My question is, how does this square with respect to confidentiality of minor records? So, for instance, we have confidentiality laws, and I just wanted to know, how does this square with that? Does this fall, does this comply with that?
This seeks to change that when it comes to student safety. And that's why we made it a very, very, very narrow scope.
Okay, and then my other question is with respect to the registry until 18.
That already exists.
I'm sorry?
I believe that already exists.
No, this is the language, the new language at section D on page 2 that says over courts, it says when a juvenile court's jurisdiction over a juvenile registrant terminates, or when the child whichever occurs later. So this answers my question. If someone is older than 18 and they're still in the classroom, then then the first part would kick in, right?
Yes, ma'am.
Okay, just wanted to make sure I understood that. And, okay. All righty, well, look, gives us food for thought. Delegate Conaway.
Thank you again for coming in. One quick question. Does this cover AI-generated pornography?
No, it doesn't contemplate that. It deals with non-consensual production and distribution of child pornography.
Okay, you might want to think about that for an amendment or something, maybe?
Sure.
Thank you.
I know what my other question was. I was looking the wrong direction, so I need to look over here. With respect to, do you know, and if you don't, it's quite all right, but do you know if in cases in which a minor is charged with any of the new offenses that are listed here, do they have an attorney who is able to assist them?
Well, I believe we passed a law that requires juveniles to have to consult with an attorney before speaking with police.
That has nothing to do with this, Delegate Griffith.
No, I'm asking, that doesn't have to, so I'm unaware then. I thought they would be protected by an attorney.
I meant in the courtroom.
Oh, I don't know.
Okay, all right, thank you so much.
Yes, ma'am, thank you.
Moving right along, we have a panel of unfavorable witnesses that are online. I'm going to call up Megan Berger, Stephen Bergman, Alyssa Fayo, there we go, Aubrey Edwards Luce. Are any of those individuals online? I see Mr. Bergman. I see Ms. Edwards-Luce, good to see you. And I can't see, but I think that is probably Ms. Alyssa Fayo. Okay, is Megan Berger? She is not in the waiting room. Okay, Ms. Berger is not in the waiting room. So we're gonna go ahead and start with Mr. Bergman, please, for 2 minutes.
Good afternoon, Madam Chair, Madam Vice Chair, and committee members. My name is Stephen Bergman. I've been practicing juvenile delinquency law for 24 years with the Office of the Public Defender. HB 12 was rejected last session because it's an extreme piece of legislation that will preclude children as young as 10 who commit nonviolent sex offenses from ever attending in-person school again. This body in 2024 precluded any child on the non-public registry from attending in-person school so long as they remain on the registry. Under current law, a child may return to school once a court terminates jurisdiction in the child's case. HB 12 usurps the authority of the juvenile court judge by keeping a child on the registry and out of school until age 18, even after a court has found that the child poses no threat and no longer requires court supervision. Thus, under HB 12, fifth graders who commit certain nonviolent sex offenses would never again see the inside of a school, even after successful treatment and rehabilitation. HB 12 was rejected last session because it's an extreme piece of legislation that vastly expands the offenses that require school exclusion. Currently, children are placed on the registry for violent, but not for nonviolent third-degree sex offenses, which are based on age difference alone. The law should not preclude a fifth grader from attending school ever again for playing doctor with a younger sibling. HB 12 would expand school exclusion to include fourth-degree sex offenses. Squeezing someone's behind on top of their clothes should not result in a 13-year-old being precluded from attending school ever again. HB 12 was rejected last session because it's an extreme piece of legislation that makes the non-public registry widely available. Neither the superintendent nor the designee, who could be anyone employed by the school or multiple people, is required to keep this information confidential. This creates a high risk that the names will become public, resulting in severe reputational damage to the child that would be impossible to repair and could lead to dire consequences, including suicide. I urge an unfavorable report.
Thank you. Ms. Edwards-Luce.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Aubrey Edwards-Luce. I'm the Executive Director at the Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore School of Law. You heard from my faculty counterpart earlier. For more than 20 years, CFCC has worked to disrupt the school-to-prison pipeline and help young people overcome barriers to school attendance, achievement, long-term success, and we strongly oppose House Bill 12. HB 12 takes Maryland in the wrong direction. Because Maryland law generally bars youth on the registry from attending in-person school, this bill would exclude more children and younger children from the classroom. Schools are not just places of instruction. They are central to healthy adolescent development. They provide structure, supervision, socialization, and opportunity. Isolating more youth from that environment increases, not decreases, the risk of recidivism and long-term harm. Additionally, HB 12 is fundamentally inconsistent with the purpose of the juvenile justice system. Our system is built on the principle that children are different from adults and have unique capacity for growth and rehabilitation. Judges are charged with making individualized decisions about whether a young person is rehabilitated and whether they pose a risk. Under HB 12, even when a court has decided that a youth is ready to move forward, that child still could be barred from school. That is continuing punishment, not rehabilitation. In his 1982 concurrence in Plyer v. Doe, U.S. Supreme Court Justice Powell wrote, "A legislative classification that threatens the creation of an underclass of future citizens and residents cannot be reconciled with one of the fundamental purposes of the 14th Amendment." HB 12 threatens the student's constitutional interest in public education by imposing broad, extrajudicial educational consequences without individualized judicial findings. Students have constitutionally protected liberty and property interest in public education. For these reasons, CFCC strongly opposes HB 12 and respectfully urges an unfavorable report.
Thank you. Next. Ms. Faia.
Yeah. Can you hear me?
Yes.
Okay. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Alyssa Fio. I'm an education attorney of the Office of the Public Defender with over 30 years of experience representing children in school-related matters. I want to first say that we all care deeply about student safety, We also believe in rehabilitation, the purpose of the juvenile court system, and in the critical role that education plays as a protective factor for children. In 2024, a provision passed during the final days of the legislature that categorically bans all children on the juvenile registry from attending public school in person. We vigorously opposed that bill at the time, given our many concerns. HB 12 unfortunately goes even further and casts a wider net by expanding the registry to include children as young as 10. Under HB 12, a child could be excluded from in-person school for years with no review, no appeal, no consideration of the court's finding that the child is safe to be in the community. This is dangerously overbroad and not narrowly tailored to promote safety. I urge you to review the testimony of Professor Latorno from Johns Hopkins and that of Juvenile Law Center. Their testimony highlights the research that shows that children who commit sexual offenses are remarkably responsible for treatment, have extremely low recidivism rates. Registries, however, cause real harm, including isolation and increased risks of suicide. Importantly, Maryland already has a reportable offense law that allows schools to receive notice of charges and make individualized safety determinations with review and appeal. HB 12 would replace that individualized process with a blanket exclusion amounting to a permanent deprivation of education without any finding that the child actually poses a risk to the school. Finally, reliance on virtual education is misplaced. Studies show it increases mental health concerns, absenteeism, and lower academic achievement, impacts we all witnessed during the pandemic. Students belong in schools where they have supervision and can access academic and social emotional supports. These students need more services, not less. Thank you.
Thank you. Ms. Berger?
Good afternoon. My name is Megan Berger. I'm the legal director at Disability Rights Maryland, the state's federally mandated protection and advocacy agency for individuals with disabilities. I'm here today to talk about the special education implications of this bill. DRM opposes HB 12 because it expands the number of students who are unilaterally removed from in-person school and whose special education rights will be violated. DRM is mandated to defend the civil rights of all students with disabilities, and this bill erodes those rights. Students with disabilities can be both the victims and the actors in sexual offense cases, and they're sometimes both. When legislating, it's imperative that the implications for all students be analyzed. School safety is of the utmost importance, but it can be achieved without eliminating federally enshrined special education rights. In 2024, with the passing of HB 814, the legislature prohibited children on the non-public registry from attending public schools in person. And this bill goes even further by impacting children as young as 10 and ensuring that a child is permanently banned until 18 years. So this means that a 10-year-old child with autism or an intellectual disability and an IEP could be banned from in-person school for 8 consecutive years. And this is the slippery slope. This is a violation of federal special education law, and it denies the students a free, appropriate public education in the least restrictive environment. The hallmark of special education law is an individualized approach by the IEP team in assessing the student's needs and determining how and where the student will receive an education. Placement decisions must be individualized. HB 12 takes this critical responsibility away from the IEP team by permanently bootstrapping the placement decision for a child with a disability to the juvenile registry. This harms children, violates their rights, and we are very concerned and want to put an end to the slippery slope. Thank you.
Thank you. Do we have any questions? Delegate Woods.
Thank you, Madam Chair. My question is for Mr. Berger. Could you tell us about any of the research that shows how children who are removed from the school are faring when it comes to virtual education, i.e. The number of children who do not have access to the Wi-Fi that's necessary, the amount of regulation that takes place in Maryland with different counties' expectations as it relates to the virtual education?
Thank you, Delegate. I'm going to punt that to Alyssa because she's the education expert. I can talk about the sex offenses, but she's the person who should answer that question.
Thank you.
Thank you. Thank you, Stephen. And thank you for that question. So in Maryland, people tend to combine the terms virtual school and virtual instruction. In fact, in Maryland, virtual schools are in fact highly regulated. Several districts have virtual schools, and those schools actually have entrance requirements. Students have to maintain, I was in one meeting this week where they asserted that student had to have an 80% attendance rate, had to have certain grade point average before being admitted. It regulates the number of hours of instruction in the classes, but virtual instruction is not regulated in Maryland. Virtual instruction is often used when students either have a reportable offense, which we see often, or when they're suspended long-term, extended suspensions, or when they're expelled. We do have data from Maryland in terms of reportable offenses, which shows us where kids end up when there is a reportable offense charge. And I might note that in Harford County, there were last year 18 reportable offense cases, and all 18 of those kids were removed and were placed in a virtual placement. So it's not like school systems aren't doing that. They are doing that. The data from Maryland also shows us that kids that are placed on virtual do not do well. Many of those children don't even log on, right? It's kind of quiet quitting. We talk about quiet quitting in employment. Well, we have quiet quitting that's going on in schools. And the virtual instruction, it's very easy to quit, right? You just don't get out of bed. You just don't log on. And back in the day, we used to have more in-person alternative schools. But once we got to the pandemic and people started using and seeing virtual, it has now become like a fallback measure. And I've had several clients who have not had internet access, were not able to log on. They did not, because we are the public defender's office, we, by definition, represent low-income families. So there is an assumption that families have access to Wi-Fi and broadband. It's also an assumption that families aren't working and that they're home to be able to wake up their child and make sure their child is logging on class to class to class. There's also an assumption that parents know the technology. I had a case where it was a grandmom, and she just could not, for the life of her, help her grandson navigate the platform.
Thank you so much. Thank you, Madam Chair.
Thank you. So I see this is a balance of rights here, and it's very difficult. It's a very difficult problem, and I appreciate the offer for a solution. Ms. Faio, I want to ask you one question about. Well, actually, I have two questions. My first question is, you were saying about the inability to appeal, and you said that the bill is overbroad and not narrowly tailored, which is usually a right, a constitutional right basis, I believe.
Right.
So can you tell me, do you believe that this is a constitutional right with respect to obtaining an education?
I would refer the committee to the testimony of the Juvenile Law Center, which actually addresses this question. The Juvenile Law Center is a national juvenile rights organization. And in their testimony, they talk about various litigation under particularly the Eighth Amendment, I believe, and also the stigma, the shaming of life concept, the presumption of dangerousness without due process. So what's really important to understand is that the bill as it's written, you don't see in the bill the permanent exclusion of school. You have to look at Criminal Procedures 11-722C. But what the current legal process, even if you're on the registry, which we think it's really problematic, the current law that bans permanently going to school, the court does maintain some jurisdiction currently. So if the court determines that no longer the student has met its treatment goals, no longer needs supervision, and terminates jurisdiction, the student comes off the juvenile registry and can then attend school. In what's being proposed in HB 12, it's a permanent sentence. There's no review. For reportable offenses, you review every 45 days. There's no appeal time. For reportable offenses, parents can appeal 15 days after each decision. There's no recognition that a court of competent jurisdiction with a lot of evidence in front of it, including expert evidence related to safety, propensity for recidivism, has considered whether it's safe for the student to be in the community and thereby in school. It's also really contradictory that we have a court saying you can be in the community, you can be in parks, you can be at the YMCA, you can be in church, you can be everywhere else, but you can't be at school where inherently you have supervision, you have structure, you have adults there, you have peers, where it's really and you also have students who are under probation already, they're being monitored, they're getting treatment. They, as Mr. Bergman would say, were the least likely group of students to offend within a school setting. I do recognize the safety concerns, but the reportable offense process allows for individualized determination, and that's what we're really trying to stress here.
Thank you very much. I appreciate your input. I find that very helpful.
Thank you.
I don't see any further questions, so that will conclude our testimony for House Bill 12. Our last bill of the day will be House Bill 25 with Delegate Addison, and who has been patiently waiting. Thank you, Delegate Addison. So Delegate, I'm going to call up who I have on the list. And it looks like I have everybody here. So I have Delegate Addison, Audrey Carter, Jeanette Gonzalez-Graham, Alani Napier, I'm sorry. Okay, can you tell me who I have? Do I have Audrey Carter? Okay. Jeanette Gonzalez-Graham? Alani Napier? Okay, great. All righty. Delegate, whenever you're ready. Thank you.
Okay, this is not present. Okay. Good afternoon, Chair Bartlett, Vice Chair Davis, and distinguished members of the House Judicial Committee. For the record, my name is Delegate Jackie T. Addison, and I would like to thank you for the opportunity to present testimony today in support of House Bill 25 concerning grandparents' visitations. This legislation updates existing visitation standards to better account for the real and lasting contributions grandparents make in a child's life. In many families, grandparents are more than extended relatives. They are steady caregivers, mentors, and emotional anchors, particularly when a household is going through a legal or personal hardship, such as separation, custody disputes, or the establishment of parentage. Periods of family transition can be confusing and difficult for children. Maintaining access to trusted and difficult for children. Maintaining access to trusted middle ground familiar family members during those times can make a measurable difference in their sense of safety and emotional health. House Bill 25 reinforces the principle that decisions affecting children should be guided primarily by what serves the children's best interests, providing courts with the authority to consider grandparent visitation after divorce or custody proceedings, help protect supportive, stable relationships that children rely on. The bill also acknowledges that when a child has lived with grandparents for a sustainable period, such as 12 months or more, that relationships may function much like a parental bond. Not to mention, the measure addresses situations involving the death of a parent, recognizing that continued contact with grandparents can provide stability and comfort during a time of loss. Critically, the proposal does not create automatic rights, but instead leaves determination in the hands of the court, allowing judges to weigh the facts of each case and decide appropriately based on the child's circumstances. I have personally experienced the positive influence grandparents can have, and I know many families share that experience. Strengthening the legal framework to recognize those bonds is a practical and compassionate step. For these reasons, I respectfully ask the committee to give House Bill 25 a favorable report. Thank you for your time and consideration. And this bill has been before you. This is the third year.
Thank you. Whoever is ready to go next.
Good afternoon, Madam Chair, Madam Vice Chair, and Honorable Judiciary Committee members. Thank you for allowing me the time to speak before you. For the record, I am Alani Napier, an intern for Delegate Jackie Addison, and a senior political science student minoring in legal studies at Morgan State University. I'm here to testify in favor of House Bill 25, Grandparents' Visitation, because of its emphasis on putting the child's needs, emotions, and overall psychological well-being first during legal proceedings. Unfortunately, during times of custody battles, paternity disputes, annulment, and divorce, grandparents are brushed under the rug. They are an afterthought in the matter. This bill ensures that grandparents who share a connection with the child similar to a parent or even took on the parental role entirely are treated with just as much respect and consideration. Personally, my grandmother played an integral role in my early childhood. She hates to be called a grandma, so I'm gonna call her my mom going forward. But my mother and father, as new parents, finding their ground, graciously had my mom by their side every step of the way. Late nights at the hospital and overnight truck drives were routine until my parents could build a foundation for their new family, and my mom was the rock through it all. She made sure I was at school on time, kept me fed and bathed, entertained me with card games, and had the Moonwalker CD on standby at all times. Even years later, when my parents bought their first home and my beautiful sister was born, my mom rode the bus up the hill to stay and help out when she could. Without her in our corner, we could have been met with many more challenges, and I would have missed out on such a special and magical bond that contributed to my character today. House Bill 25, Grandparents' Visitation, allows for magical bonds, like my mom and I's, to prosper despite unfortunate circumstances. It allows for grandparents to offer stability and comfort during a time that a child needs it most. I couldn't fathom going through a traumatic experience without my mom in my corner, and I would not wish that on any child. Therefore, not only do I support this bill, but I hope all members of the committee will have a favorable report on House Bill 25 as well. Thank you.
Thank you. Next.
Good afternoon, delegation. Thank God, and thank you, Delegate Addison, for inviting me to testify regarding grandparent visitation rights. My name is Audrey Carter, and I'm here as a grandparent in support of House Bill 25. I have two grandsons. From the day they were born, they live with me more than their own parents. I've provided for them physically, financially, spiritually, and emotionally. I was their primary caregiver, but I did not have legal custody. This legislation is even more important to me now. My only son, which is their father, was killed on June 9, 2018. At that time, my grandchildren were 8 and 13 years old. And around the time of the COVID pandemic, they went to live with their mother. After that, I was essentially cut out of their lives. Imagine losing your only child and now your only grandchildren. My priority is the safety and well-being of my grandchildren, not interfering in a parent-child relationship. Ironically, just 2 days ago, both my 15-year-old grandson and their mother called to say she was putting them out the house for not shoveling the snow. I told them, work it out. It's difficult raising children these days. They grow up so fast. With the changes in juvenile legislation, grandparents should be next in line to assist when the well-being, safety, and best interest of the child is at stake. We could also help the parents who just testified in House Bill 48 so our children don't go into foster care. Passing this law will support grandparents who are willing to help their grandchildren and parents, even when parents are unwilling to admit they need help. As grandparents, we can provide the mature, loving, and patient demeanor that children need. House Bill 25 should be passed to support our role as a means of extended help, resources, and wisdom to both parents and grandchildren. This legislation will protect the rights of grandchildren grandparents like me who want involvement and inclusion with their grandchildren. For the best interests of children, I urge you to pass House Bill 25 regarding grandparents. And a lot of these bills would be unnecessary if grandparents were more involved. Thank you, and God bless you for this opportunity to speak.
Thank you. You make a.
Good afternoon, Chair and members of the committee. My name is Jeanette Gonzalez-Graham, and I'm a dedicated reentry leader who works every day to support families impacted by incarceration. I'm also a grandmother. Today, I stand before you not just as an advocate, but also as someone who lives in the reality of not being able to have contact with their grandchild. Being separated from families, especially a grandmother and a grandchild, starts that initial neglect of childhood adverse experiences. My son is serving a 25-year sentence. As he pays his debt to society, our family, especially my granddaughter, has to deal with not knowing where her father is. The birth mother withheld access to me many times, also have used as a financial gain. Because I have no legal rights, I'm powerless to ensure that my granddaughter receives the love, stability, and relationship she deserves with her extended family. This has caused pain not only to me, but a little girl who suffers through emotional disconnection, no fault of her own. The extortion is real and is very sickening that I spent over $2,000 for a child that I can't see or at least have a relationship with. What we're discussing here in House Bill 25 is that it's more than legal language, a child's way of being and continued care of love. There should be a bill that allows grandparents visitation rights. Being a single mother, it should be really extreme for her to not be able to not only use money from us, but also get the support and help that she needs, rather than using it and abusing it. I do not want my granddaughter growing up with knowing that her father made a bad decision, but then she doesn't have access to her remaining part of the family. For that, I truly believe that we all should have a favorable response in House Bill 25. Thank you.
Thank you for your testimony. Delegate Arakan.
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill. I just want to, we've over the years in Judiciary had bills like this come up a lot, and you said you've put this bill in 3 times, and I know this is an important issue, and grandparents do play a really important role, and especially in my children's lives, they're really important. But this case has been tested already. It's made it to the Supreme Court, and it failed. Are you familiar with Troxel v. Granville? The case Troxel v. Granville?
No.
It was a bipartisan position from O'Connor, Ginsburg, Breyer, some others. And the ultimate finding of the Supreme Court was that if the parent is fit, then they get the ultimate authority, and the court cannot intervene in deciding what is in the best interest of their child. If they are unfit, there is an avenue for grandparents to gain access, but you have to prove the parent is unfit. So in America broadly, because of this ruling, it's very unlikely a bill like this would actually end up being implemented, because we've already had it make it to the Supreme Court, and they have decided fit parents make the ultimate decision of best interest, not the state, period. I just wanted to make sure that the sponsor understood.
Thank you.
Isn't that so?
Thank you so much.
Okay, if you want to respond.
You mentioned, can I? You mentioned the bill, although I'll get exactly what it is, Granville something, Supreme Court? All right, so my question would be unfit, because I literally went to court to try to get joint custody of my grandchildren because they live with me for literally all their life. And when COVID hit, she wanted them home with her. And so when I tried to get joint custody of them, they said I had to say she was unfit. Now, unfit in the sense of she never brought anything for them, she never fed them. Even when they went back to her home, I was still paying for their clothes because I was still sending them money for food. So when you say Supreme Court and they say unfit, now she may have been unfit, she may have been, I guess, okay, but in the sense of what is considered unfit when she's not taking care of her children nor for her children, and a grandparent has done this, and I've found out later that I should have been considered a de facto parent because of all the things that I did for them and continue to do. So when you say the law was unfit, so do they define unfit?
Yeah, so that there would be case law tells the judge how to establish whether or not a parent is fit or not. And so in that case particularly, they may have just not found that there was enough evidence to show that the parent was unfit.
Delegate Moreno?
Yeah, so it used to be known as the Taylor and Sander factors, but I believe a year ago, they were actually codified. So that's a list of different characteristics that would make a parent unfit. So the burden would be on the grandparent trying to seek that co-custody or full custody, and that burden is a difficult one. Even if the parent is not the best parent, there's still deference to that biological parent or parents.
So you heard me say in my testimony, my 15-year-old just called me 2 days ago to say his mother put him out the house.
File again.
And you
Is
have
that considered?
and you would have to take that to court. Like we're limited. We pass legislation.
Oh, no, I understand that,
Yeah, we
but
don't make court decisions.
Would that be considered unfit?
Here's the thing that
Forgive
we
me.
want to, here's the thing that we want to be careful with, and I appreciate this, and that is giving legal advice. But I do appreciate, they're ready, can you see that they're ready to fight for you, and that's great.
I haven't thought,
Yes.
I've seen it time and again.
Yes. Okay, so we're going to move on to Delegate Phillip.
So I am, this is one of those bills that continues to come back because it's a reality that we're facing in our communities, particularly in the African-American community with grandparents raising their grandchildren. I do think that there are some provisions in the law that provide some relief. My question is, and maybe this is a thought for the sponsor of the bill, the exceptional circumstances have been kind of developed by the courts, what that looks like. There may be some tweaking of that we might consider, but you need to look at that and then perhaps let us know what you might think would be more appropriate for those exceptional circumstances that the court needs to look to. And that's different from unfit.
Yes.
And so from a legislative perspective, Madam Sponsor, I'm just asking you if you would look at what exists and perhaps come back to us with something?
I will, and I'll be back next year.
No, they don't pass.
Okay. I have one question.
Go ahead.
For our grandmother. I'm a grandmother too. Grandparents are great. You kind of alluded to this, and you said you found out later that you might have been a de facto parent. Can you talk about that just a little bit in the sense that did you do anything going down that route as a de facto, possibly as or claiming that you were a de facto parent legally?
When they went back with him, I filed for joint custody. And when we got to the court, the judge literally said, unless you can say she's unfit, then I can't rule in your favor. So, of course, I didn't know. So after I'm doing some more reading and research of what can I do to help my grandchildren from a legal standpoint, I read, if you've taken care of your grandchildren, if you've done all these things for your grandchildren, they've lived with you more than a certain amount of time, and all of these things, you could have been considered a de facto parent, which meant that technically I could have been given joint custody because my son passed away, and they were actually living with me when my son was alive and not with their mom. And so when I looked that up, I'm going, why didn't, not that the judge had to give me legal advice, but he knew.
But I guess what I'm asking is.
I'm sorry, ma'am.
Now, with that information, do you feel that you're in a position, and you don't have to answer this question because you may want to take the legal route later on, but I was just wondering if you had considered taking the legal route of becoming a de facto parent. That's my question.
At this point, if my grandson calls me again, yes. One grandson is now 20 years old, so he's just, they call me Nana. He's coming with Nana, he's just doing whatever.
Right.
My 15-year-old, I know for a fact, if my older one comes with me, he's going to come too. And so if these kind of situations continue where it's some contention or whatever it is, Mom has been very difficult in accepting, I guess, my presence because of, just my relationship with them. But in this last instance, I have said to her, you guys work it out with whatever happened between y'all two, because I don't know. But if I get involved, I will call the police so that we can deal with this. You can't, because you can't put a 15-year-old out of your house.
Okay, okay.
So, but I will, I will
Okay.
definitely
All
consider
right.
and pursue it. Thank you.
Delegate Conaway, and then I'll get to you.
Delegate for bringing the bill and panel. Did you consider, and I know you only had about 5 minutes, have you considered to get some advice on this bill and maybe put an amendment to it? How about yes? And I'll talk to you about it later. Thank you.
Yes, yes. We aim to please here in Judiciary. Delegate Woods.
Thank you for your testimony, and I want to preface by saying thank you for the work and commitment and love you've put into raising your grandchildren. I do want to kind of flip the script a little bit, and I want to ask if you would consider a provision that addresses, because there are instances, and I just noticed because of the work that I've done, where children who have been traumatized or who have no desire to visit with their grandparents, and that is a reality. And so I'd like to know if you consider a provision to that.
Thank you, yes.
Thank you, Madam Chair.
So I have a.
Did you answer?
I did, I said yes.
Okay.
I said yes.
Did you want to add more to that question, or did you want to add something additional?
I just wanted to add that this young man behind me missed the deadline and drove all the way from DC.
Oh, well, that's a whole different matter. Hold on one second. Delegate Taylor?
Thank you, Madam Chair. And I also want to say that, for the sponsor of this bill, thank you for continuing this effort. And I think somewhere in here, there's an answer. And I just implore you to keep going. And I also wanted to say to your wonderful granddaughter, who is a student at Morgan State University, who I have had two, and I also have a senior there now. But that is a great university, isn't that so?
I just want to preface that Delegate Addison, even though I love her, she's not my grandma. She's not my mama. But yes, go Bears. I love Morgan State.
Excellent, excellent. Okay, Delegate McComas.
Okay. I think that maybe what you need to do is take Delegate Conway's advice, and I think maybe do a little internet search, okay? Because if you've got a student at Morgan State, the other thing is you may want to just say, hey, grandparents' rights or something in Maryland, and kind of see what you can do. Grandparents are vital because they link the kids to their heritage. And I lived with my grandparents, and I learned all about World War I, about World War II, mustard gas, the whole bit, And I just think that people need to know their family history. And so I think grandparents rock, and they're great. And so I do, figure out something that we can do something to help move the needle a little bit, because it is important. They are very, very important to families, and we need to support the family unit. And I'll just give you an example. My grandparents took care of their parents, and the grandma was from Ireland. She was feisty, and grandpa was feisty too. They're my great-grandparents. Anyway, I didn't really know them, but the point is they get mad at the kids. They had 12 kids, so then every 3 months they'd go with the other kids, their other children, and then they get mad at them and move back. So, but they were really cute. So I guess what I'm saying is I just think they're really needed. So carry on and make it happen somehow.
All righty. Okay, Delegate Stinnett.
Thank you, Madam Chair. I hear all this Morgan State talk. Next time, have somebody from Coppin State. But this bill is, to me, is very, very important, because I'm even thinking about the the children that may go through or may have that traumatic challenges as far as being separated from the grandparents, especially with those that have special needs. I think that's very critical, because at times that I'm close to a situation that, you know, the parent's home, it's not stable enough, and the grandparent is taking more of the time and the brunt as far as taking care of those kids. And I've been communicating with them as far as, should you, go through the legal route to kind of protect yourself, because it'd be very, very traumatic, not only to the children, but also even to the family itself, as far as if that's permanent separation, and really trying to take matters and be more forthcoming as far as taking care of those matters. So I really like this bill. I think it's very important, so hopefully we can get it passed.
Isn't that so?
Thank you so
All righty.
much.
Thank you, everyone.
Thank
I
you.
appreciate your testimony, members of the House, of the House Judiciary Committee. Thank you all for testifying. And I'm sorry, with respect to the gentleman who is here, no, you may not testify. However, you may supply a written testimony. You can email it to the main email address on the website, and we will all see it. Okay? Thank you.
Thank you so much.
Thank you.
And y'all be as kind to me.
So that concludes our, no, it doesn't conclude. Hold on one second. I have, just 1 second, please. We had one more person, but my understanding is that she's not able to testify due to bronchitis?
That was not told to me.
Is she, do you have her on?
I do not have her
Okay,
here.
all right.
So yes, no, we're good.
Okay, so that concludes our testimony for House Bill 25. Members, that concludes all of our testimony for today and all of our hearings for today. Drive safely and good night.